Pardon, my lordship. I want to mention that 3 weeks gone, my lordship, matter cannot reach, my lordship. 3 weeks gone, but matter cannot reach in the court, my lordship.
Which item?
Cannot reach.
Item not I mentioned the memo to file the list the case, and
Yes.
the petitioner is ill, seriously ill, my lordship. Kindly be listed.
On matter, I have made a mention. It was in the last 3 weeks. It was in the list. After taking up in orders matter, 2 interim applications are filed. A
Now
person
we
can,
are taking a fresh admission matter.
but he will be terminated at any time. Your lordship, though your lordship is
Yes, yes.
protected,
Yes.
day after tomorrow.
My lords, my dear order dated 18th September, you had asked for a matter to be listed on 30th. It's a fresh matter, my lords. So, my lords, it has not got listed.
Please.
Oh, my lords.
My lord, item 74 of the list.
Mhm.
74
Hmm.
of the list, my lord.
Hmm.
Can we permit to withdraw?
Read appeal.
You are for the petitioner.
My lord.
Appellant.
My lord.
All right. Withdraw.
Number 78, my lord, it was a parted matter, your lordship.
78. 78 years.
It's a parted matter, your lordship had heard it at once. Your lordship had put it today in my argument. My lord, I was just asking, my lord, will your lordship take it first or after?
No, we'll go on with the press admission, then we'll take. Yes.
With my lord's permission, your lordship, last week this matter was there with Mr. Spalit had argued the matter and sought liberty to file a written note. I'm filing it today, your lordship, my candidate.
My lord, the last two matter in last matter in the list, my lord. Will mention the matter has not come. It was delisted. Can be listed for orders. Mr. Mohanty has come from the side of OPSC probably. He can take notice.
Did not get the copy. I wanted inform, I have gone through it. So the prayer of the petitioner still is covered by the judgment of the Supreme Court in 2004 6 SCC 794 Pramod Srivastava. There is no provisions
In the rule.
devalues.
If there is no provision in the rule, it's not.
And in the meanwhile, lordship might be knowing the foundation already gone. They have been also appointed. The OPSC as per I remember rule 27.9. Lordship on the other day as much as the books that is requisition by the government, only to that number recommendation gone. All posts fill up and they happen. So this is the position. And for any further instruction, you can give a copy after vacation lordship. So that's it.
It's not for encounter. I have all the answer to this. I have all
And
the
one thing, chairman should not be made. OPSC should be made through the secretary. Chairman is a constitutional post holder. He does not. He is not responsible for.
You want to obtain instruction and file counter.
Yes, let him file.
File. You are asking for whom?
OPSC.
OPSC. Only the chairman may be deleted.
Through secretary, yes.
Secretary through.
OPSC.
I'm permitted to correct here.
Here give me OPSC 6 on time to file the counter in this petition. Put up this matter after we are on the day of the trade day. There are the counsel for the petitioner 6 publication correct the constituency
In respect to appointment number 2.
opposite party number 2. And they were mentioning the secretary in place of the chair.
OPSC through secretary.
Yes.
to just give it. Are you, it is a paperless filing, so you have to just give that space.
Yes, yes.
A copy of the report, sir.
Copy of the get a copy of the requisition.
दिखा दीजिए मतलब दे तो एक नहीं क्या
Yes,
That is also like.
yes, sir.
But it is extensively hard yesterday.
No,
you have to go for
Next
So,
time,
no, I'm not that.
next time in the list, let my name appear so that I cannot miss.
Yes, next.
कॉपी दीजिए
Item number 4.
item number 2 my lord in this case
Item 2, my lord, this is a railway matter. I didn't receive a copy. Let my learned pen serve the copy of the same to East Coast Railway.
Copy of the. Copy.
of course I will give you
So parties and submit that yes, not. It's not the the reports of the day. It's not the copy of the distribution. Mr. Party will come next week.
Yes, ma'am. Yes.
Any CGC
Next
name
week.
you want to implicate here? Apart from your name, any
Anyway, Mr. B.
to be done?
Yes, along with me, Mr. B.K. Padi name will be
BK Party.
Mr. B.K. Padi, Birendra Kumar Padi may be.
Okay, BK Party. See. All right.
Item number 3.
My lord, the petitioners are the husband and wife, my lord. They have purchased a flat hearing number 2006, second floor of Akar Infra Design from with the consideration amount 73 lakhs, out of which they have paid 14 lakhs 60,000, and the rest amount has taken loan from a Union Bank, my lord. But my lord, Canada Bank has issued a notice, my lord, on where they are not the loaning, my lord.
We are doing this search over the property, and we came to know that that particular builder has been created mischief, and ultimately they have sold the land. So their ultimate remedy is under section 17. If they so agree, they can go to the.
All right. This told of 17. Yes.
Appealing for the
My lord, my humble submission is, my lord, I am not taken loan from the Canada Bank.
Raise all those things before the PRP. Okay.
Item 4.
My lord, the petitioner, they agreed by the annexer 6 that the order dated 28/8/2024. The Lord and Cat declined to proceed in a contempt petition, my lord, even if there is a specific direction by the Lord and Cat, my lord. That is the case is
What order you are challenging?
challenge the annexer 6 that contempt petition. They dropped the contempt petition without directing to the opposite party to implement the order. My lord, is a compulsorily retired. My lord, kindly have a glance, page 25. That is the operating portion of the order, what Cat directed, and my lord, I am permitted to place
25.
25.
Yeah.
My lord, in the bottom of the order, my lord, as a consequence, the respondent are hereby directed to grant the applicant all consequential service and financial benefit within a period of 60 days from the date of receipt of a copy of this order. That is in the result way is allowed. While compulsory retirement quashed by the London Cat matter. Thereafter, the department approached this honorable court by challenging this order in annexer 2 matter. That has been also confirmed by dismissing their writ application. The Union of India represents through railway.
Just let us see the operating part of the order of this court. Court number.
My lord, this honorable court.
Lecture 2. Petition being dismissed. Okay.
My lord.
Then. Contempt petition filed.
Then the contempt petition, my lord, filed before the learner cat, my lord.
Okay, so
Say, filed. In content petition, they filed a so cause saying that we are going to implement it, but they did not implement it.
which line?
In Annex 4, my lord, page 54, that is the CP, that is show cause.
Annex 4 paragraph.
Paragraph. That in paragraph 6, they have said, my lord, that in view of the above, it is humbly submitted that respondent number 6 has filed a read petition on dated 3/6/23 by the WBC number 18,070. What I placed before my lords in Annex 2. 18,077 of 2023 along with I number so and so operation of impugn order dated of the honorable before the honorable High Court in Orissa. During such pendency, that so we are waiting the order of the honorable High Court. So that's why this was they are so called at the relevant time. After disposal of the case before the honorable court in Annex 2, they did not do anything. So that's why I placed the contempt before the honorable cat that my lord, the honorable cat will be pleased to direct to the opposite party to implement the said order, as it is specific, but the consequential order that which has not been given. Corridor name, my lord, my lord, I am placing. Sorry for what I'm in Annex, my lord.
So called is Annex 4.
Oh, Annex 4, my lord. You are operating from started from High 4.
Paragraph to देखो
से एटा कहले that in view माने paragraph 6 रे से कहू
पुरा सेटा तो कहले जे डब्ल्यूपी सेटा पेंडिंग अछि सरले जा हबो
हां सेटा
तापरे वेयर दे हैव
respondent highest regard to court of law एथि कहि कि से एटा कहि कि से फाइल करले that the respondent have highest regard the court of law and never disobeyed the deliberately willfully against the honorable court's order alleged by petitioner. The respondent have agitated the same by filing the WPC with the High Court. In view of the fact circumstances, the content may kindly be dropped. एथि से कहले आउ तापर से किछि कहले नै तापर I pressed the content petition before the honorable tribunal. Honorable tribunal in paragraph 6, without considering such aspect, dropped the content proceedings.
Page 67 or 68?
My lord, 67. My lord, my lord.
Let's
my lord, in paragraph 67. We have considered the fact of the entire matter as discussed above, but we do not find any justification to hold that there has been any intentional or deliberate violation of the order of the tribunal by the alleged contemptor. As we are aware about that, contempt jurisdiction is a powerful weapon in the hands of the courts of law, but that by itself operate as a string of caution, and unless thus otherwise it is established that disobedience of the order is willful, it would neither fair nor reasonable for law courts to exercise jurisdiction under the contempt of court. Suffice to take a support of one such decision of the Honorable Apex Court in so and so Dr. UN Bura and ex-Chief Executive Officer versus Assam Rule of Floor Meets Association and another so and so, and have held that precondition for initiation of proceeding under the Contempt of Court Act against any authority as per law is the disobedience must be willful, deliberate and intentional. The contempt power cannot be used unless the court is satisfied beyond doubt that person has deliberately and intentionally violated the order of the court. In view of the discussion made above, since there is no willful, deliberate and intentional violation of the order, this tribunal is not inclined to proceed further in the CP. However, taking into consideration the grievance that early settlement would enable to applicant to meet the medical expense, we hope, trust that the authority concerned shall do well in page 16 matter. Do well and settle the matter at the earliest after receipt of the required information and it is document from the applicant. In the result, CP.
Mr. Pari, so now the writ is dismissed, so you have to implement the order.
Yes, my lord. This is as regard to the content petition is concerned, basing on the SOCUS filed by the government of India. What record
right, but what about the direction in the OA?
The OA direction is
in page 25.
Come to page number 25.
Yes, internal page 9, my lord.
Right, right.
Yes, the last one, as consequence, the respondents are hereby directed to grant the applicant all consequential service or financial benefit within a period of 60 days from the this.
So
This is
that
the direction of the tribunal.
that period has elapsed in long because this order was passed in 31/3/23 and your writ petition has also been dismissed. So you have to implement the order. You take instruction when you
Yes,
are.
yes. Better I will take instruction.
All right, that will do.
No, is there any instruction after the dismissal of the suit passed on to you communicated to fill up certain form? As it is written, thereafter the applicant was communicated in form number 6, asking him to fill up the same and submit with all required documents mentioned therein along with the service certificate.
Any order, my lord, any consequence person to the honorable tribunal's order.
After the petition, you have been communicated this or before that?
After
In order to implement the order of the court, that because you have already been superannuated, so it will be reinstated in the same place and other consequential benefit is to be granted. So in terms of that, you have been asked to fill up the form and to submit it before the authority.
But my lord, my respective submission before my lord, they did not implement the order, the consequential order.
No, it is stated
that's why I am not able to.
My lord, is that whether you submit the application or not? This is
instruction
contempt petition order जोटा ट्रिब्यूनल कले से तर जस्ट ऊपर पारा सेटा से लिखा है कि he was asked to submit certain form with documents. It is stated that till date the applicant has not submitted form 6. Hence it is reiterated that
consequential service and this latest designation that I was a senior clerk there, and how I will fill up the that is form 6 is there, the latest designation and the latest scale of everything I will disclose, but they did not give. So that's why I am before the tribunal and thereafter my lord.
So this form number 6 can only be filled up after you are reinstated.
After reinstated, my lord. But they have not. So that's why they take
that is how if clear thing comes because it is already there. The tribunal has mentioned it. So the Indian government has to take up this also. Why they have asked for this form 6 to be filled up before implementing the order.
So that's why, my lord.
My lord, I am not clear about this, but what my lordship Puri is it very correct. They might have asked this form to fill up. Thereafter, the case will
No,
be
kindly see,
not that after
he cannot fill it up unless you
He's employed.
You take
Take instruction, my lord.
Imposed
compulsory.
compulsory retirement. He
Yes.
is not in service. So by virtue of this order, so
yes.
he has to then the submission then can only he mention all those things in that form number 6. So it is not possible on his part to fill up that
Yes.
form unless he is taken back. So that instruction also you get it, and we are taking up this matter after Puja holidays.
Well,
the writ petition has been filed by the petitioner Janakar Patno, challenging the order dated 31/3/2023 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number so and so. It appears that the petitioner approached the Central Administrative Tribunal in the aforesaid case against the challenging the order dated 5/4/2016, imposing punishment of compulsory retirement on conclusion of disciplinary proceedings initiated against them. The learning tribunal had order dated 15/3/2023 has been pleased to held that the order of compulsory retirement is not sustainable in the eye of law, and accordingly it was recessed. And taking into account that the applicant has already reached the age of superannuation, directed the respondent to grant the petition of all consequential service and financial benefits in a period of 60 days from the date of receipt of the copy of the order. And accordingly, the original application was allowed. It appears that the opposite parties challenged the order of the Grand Tribunal before this court in WPC number 1877 of 2023, which was dismissed for order dated 8/5/2020. After the way was allowed, since the opposite party didn't implement the order of the Grand Tribunal, the contempt petition was filed. Here in contempt petition civil number 19 of 2023. With a prayer for direction to the opposite party to comply with order dated 31 of 2023. Focus was filed by the opposite parties to the contempt petition, wherein stand has been taken that since the matter is sub judice before this court in WPC number so along with IL number so, therefore there was no willful disobedience on the part of the opposite party in complying with the order of the Grand Tribunal. Ultimately, the Grand Tribunal in the contempt proceedings has been pleased to hold that there was no willful, deliberate, or intentional violation of the order of the order, and therefore the contempt petition along with the MA number 600/2020 was dropped. However, the Grand Tribunal observed that the authorities' concerns and do well to settle the matter at the earliest after receipt of the required information and documents from the applicant. In paragraph number 5, the respondent, while filing the show cause to the contempt petition, stated that the petitioner was communicated with form number 6, asking him to fill up the same and submit all the required documents mentioned therein, along with the service certificate particulars, giving therein details in superstition of the earlier certificate issued on 31/5/2016, consequent upon his compulsory retirement. However, the applicant has not submitted form number 6. The land counsel for the petitioner submits. What is your submission?
My submission that if the respondent will give the consequence, the implementing the order of the tribunal, then my latest designation that what in which position
What is form number 6?
Form number 6 is that is to give the details, the photograph of wife and my lord the latest position, the designation. That is designation what I am.
ଛାଡ଼ି ଦିଅନ୍ତୁ ସେଟା ଅଫିସ ଫିଲ୍ ଅପ୍ କରିବେ ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ଆପଣଙ୍କ ଯେତିକି ପାର୍ଟ ଅଛି
ନାଇଁ ସେମାନେ ଆକ୍ସେପ୍ଟ କଲେ ସିଏ କହୁଛନ୍ତି ଯେ
ଦେଲେ କି ଆପଣ
ଆମେ ଦେଲା କନସିକ୍ୱେନ୍ସିଆଲ ଟା
ଦେଲେ ଆଜ୍ଞା
form number 6 fill up କରିକି ଦେଲେ
ନାଇଁ ଦେଲା ବେଳକୁ ସେ କହୁଛନ୍ତି ଫିଲ୍ ଅପ୍ କରିକି ଦିଅ ମାନେ ଆମେ ଯାଇକି ଦେଲୁ ଯୋଉ ଫର୍ମ
ଆପଣ ଦେଲେ ତାଙ୍କର ଗୋଟେ ସେଟା କମ୍ପ୍ଲାଏନ୍ସ ଟା ଦରକାର ଆପଣ ଦେବେ ସେ କହିବେ ଏଟା ଫିଲ୍ ଅପ୍ କର ବୋଲି then the question comes
ଆପଣଙ୍କର oral submission କଣ ହଉଛି ଯେ ଆପଣ
oral submission my lord the latest consequence as per the order of the tribunal but the consequential that is
ସେଇଟା ଆମେ ବୁଝିନୁ ଆପଣ form number 6 ଟାକୁ ସେମାନେ ଦେଲେ fill up କରି ଦବା ପାଇଁ ଆପଣ ଦେଲେ ନାହିଁ ସେମାନେ କଣ ଆକ୍ସେପ୍ଟ କଲେନି ନା ଆପଣ କଣ କହୁଛନ୍ତି?
ସେମାନେ କହୁଛନ୍ତି ତମେ ଡିଟେଲ୍ସ କଣ ତମର ପୋଜିସନ ତମେ ଦିଅ କିନ୍ତୁ ସେ ଦେଇନାହାନ୍ତି ବୋଲି ଆମେ ଦେଇପାରିଲୁନୁ ସେ ଲାଟେଷ୍ଟ
where you were compulsorily retired was the last post. That is the last post you will get. ଦେଇଥାନ୍ତେ ଆପଣ କିଏ କଲା ଆପଣ?
ସେ ସେଟାକୁ ଏଇ ଯୋଉ କନସିକ୍ୱେନ୍ସିଆଲ ଟା ଦିଆ ହେଇଛି ବୋଲି my restored submission before my lord. Say that's why such position has not been clarified them what you are
No. The last.
my lord.
What he was stated in the writ petition about that form number 6. You come to page number 10.
10 my lord. 10 my lord. That my lord, it is started from paragraph 7. That the prayer of the petitioner to A 65020 was quashed to order the compulsory retirement 5416, which was allowed on the London Tribunal on 31/3/23 with a direction to the opposite but to grant all consequential service and financial benefit in favor of the petitioner within a period of 60 days from the date of receipt of the copy of the order. Even after lapse of stipulated period, due to non-compliance of the order dated 31/3/23, the petitioner preferred CP number 19/23 before the London Tribunal, and on being aggrieved by order dated 31/3/23, the opposite parties preferred writ petition before the Honorable
You come to that so far as the grant of consequential
consequential and final assignment to which the petitioner is entitled to the promotional post of office superintendent and then to chief, my lord is justified, and then to chief office superintendent has not been given.
The promotional post appropriate compulsory retirement hichi. It is not punitive. Compulsory retirement is not a punishment.
It was also disclosed in the affidavit that though the opposite parties had sent blank the form number 6, my lord, to the petitioner fill up and to submit before the railway establishment for grant financial immunity, yet the petitioner had not accepted the same, and because petitioner came to know from reliable sources that promotion post have not been given. My lord, এইটা সে ଦେଇନାହାନ୍ତି ବୋଲି within a period of retirement that is 82/2020.
Form number 6
has not been accepted.
In the writ petition, it has been mentioned that the petitioner had not accepted the form as he came to know from the reliable sources that the promotional posts have not been given within the period of retirement, that is 8/2/2020. In paragraph number 8 of the writ petition, it has been stated that appeared in person before the London Tribunal or submitted
that under the circumstances.
Under which circumstances he was not able to receive form number 6.
Hearing the parties on it, the London Tribunal dropped the contempts. Declared to take up the tax. There is no willful.
The person that the petitioner had not accepted the assembly body discipline of the football. Mr. Paris and the General also appearing for this one to submit time for any instruction matter about this matter on such answer to your yes. Aukar Nahar
Along with me, Mr. Guchayat is appearing. Yes, D. Guchayat, along with me, Deepak Guchayat.
Deepak Guchayat.
All right.
Item 5.
Please, your lordship. Well, rejection order by the answer 6.
Use the mic.
Is answer
Yes,
6.
that is fine.
I permitted to withdraw and the him to
Petition submits that since the influence order is appealable, he will be permitted to withdraw the petition to submit appeal before the appellate authority. According to the petition is disclosed as that is right.
Item 6.
May I please, your lordship? My lord, I am on BC, my lordship.
Yes, sir.
My lord, the petitioner, my lord's unfortunate petitioner, his father died in 2022 at the age of 37, my lord. Their land, parental land,
Your
been taken.
representation is annexure 9.
Yes.
But annexure 8, if your lordship kindly come to annexure 8 page 30, it will make the position clear. That is against the father. My father has also applied, but he unfortunately expired at the age of 30.
Let them
Disclosure.
representation.
My lord, may kindly indicate this annexure because they say that father has missed his age is 85, but when Aadhaar card was issued, he made it 87.
You must have clarified that in annexure 8, 9.
Annexure 9 ଟା clarify କରିନାହାନ୍ତି.
Do you file a fresh one?
Fresh file କରନ୍ତୁ.
Yes, I'll. Your lordship.
The counsel for the petitioner submits that
Sir,
no presentation has been filed before the
unmarried daughter.
authority. Had annexure 9. For providing employment under the LR policy. But since these particulars are not mentioned in annexure 9, the petitioner may be permitted to file a fresh representation before the authority. Which authority you are to file this?
MCL. MCL.
OP number 2 because that is the
OP number 2.
OP number 2.
So, before the opposite party number 2, General Manager, Infra, Area, Mahanadi, Court. So, disposed of that 4 weeks it will file. Within 3 months they will decide it and communicate the order within 15 days.
Can it be little early, my lord? I'll give within.
You file within 4 weeks. Give all the details. Don't be in a hurry and leave something.
Okay.
Give the entire particulars and.
Yes. I'll do that.
Item 7.
Yes, item number 7.
May I please, my lord? My lord, here the petitioner is a widow, belongs to scheduled caste community, my lord. He is before your lordships against the forcible, the opposite parties are trying to forcibly grab her Sthitivan land, my lord. And my lord, they are doing this action without following the due process of law as prescribed in the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation Resettlement Act 2013, my lord.
This letter was sent on 5/9/24.
My lord.
Collector.
My lord. But my lord, I humbly bring your lordship's notice that when it came to the notice of the opposite parties that a writ petition has been filed, that the opposite party number 2 had instructed one contractor that he dig.
You filed a representation for payment of compensation.
Yes, my lord. Because my lord, one humble submission, my lord. My lord, one humble submission I want to advance. Because there is development during pendency. The contractor had already started digging my land, my lord. And my lord.
Get the compensation, what is there? Yes, next.
Yes, pardon, my lord.
You have to get compensation. We have directed the authority to consider it.
That my lord, opposite the collector, my lord.
Yes.
My lord, till that, my lord, no action to be taken.
Why we have given the direction?
I am protected, my lord.
Protection कौन होगा?
My lord,
get the compensation.
Item number 8 here.
You have to get the compensation.
Yes. Item 8.
Here the petitioner has filed an application under section 28.
Disposal of your annexure 2.
28.
That is pending for the OP number 2.
Next.
Item 9.
Similar order.
Annexure
Annexure 4.
Annexure 4 देखिए
Nine.
next annexure 9 how would have been
10.
item now 9
10.
71 also, my lord. 71.
71.
71 also same
Similar.
9 10 and
71.
Item 11.
My lord, this is the matter. I am challenging the order of the Learning Tribunal, Central Administrative Tribunal, because the petitioner before your lordship appointed as librarian in the year 1981, my lord. In Kendriya Vidyalaya Sangathan, my lord, is a society under Society Registration Act. 86, the government took over Kendriya Vidyalaya Sangathan. That's on our Annexure 1, page 12. The petition appointed in the year 81.
which appearing
My lord, that generally S.K. Patnaik, senior advocate, appears.
copy to him
This is order कर लेंगे.
it is stated at the bar that Mr. S.K. Patnaik
Pankaj Patnaik.
also needs to appear for Kendriya Vidyalaya Sangathan. Get a copy of the writ petition we saw
My
from
lord.
the council. Put up this matter next week indicating the name of Mr.
My lord.
in the cause this case. S.K. Patnaik, no?
My lord. Oblast.
Item 12.
12 and 13. State by man can I keep on Monday man.
Non-council for the state 6 for 9 next week. Next week. Okay. 12 and 13.
Item 14.
My lord, the petitioner is challenging the order of the collector by Annexure 7, ma'am. They have rejected my application to get the compensation under the Land Acquisition Act, my lord. They are rejected on the ground that the ROR issue in favor of the petitioner by Annexure 1 has been cancelled.
Annexure 7.
7, ma'am.
Please come to the operative part.
My lord. Page 25.
Come to that perusal of the report of the council.
My lord. Perusal of the report of the Tahsildar Hingiri reveals that though the petitioner Ramsagar Oram had been settled with an area of 4.90 decimal of land classified as forest in village Mangarapur under the Forest Act 2006. His livelihood depend on the possession of the land has been revealed re-verified jointly by the forest and the revenue officer as per the direction of the state level committee. My lord, they have not my lord, monitoring committee. As for the finding of the joint inquiry, all the title granted under FRA 2006 of village Manharpur, including that of the petitioner Parameswar Oram, on the ground that the petitioner could not conclusively proved his possession over the forest land prior to 2005, my lord. My lord, they have not given any opportunity to hearing or.
We just read it next paragraph.
My lord. Further, I reveal in the summary report of the visit of the Secretary, Ministry of Tribal Affairs of Odisha on 26 February 2014, it has been clarified that the proceeding under FRA is not a judicial or is an administrative order. Therefore, in case of administrative authority find that the mistake has been committed, they will be competent to review the order after following the principle of natural justice. But they have not given the opportunity. Since the title of forest land granted earlier in favor of the petitioner has been cancelled by the district level committee following the procedure.
Following due procedure.
Yes, ma'am, due procedure. The payment of the land
compensation in respect of the such forest land does not arise.
In your case is that no opportunity has been given.
My lord.
Where is the ground taken in that is in your expedition?
It was a para 9, my lord.
Right. Forum
Plus 6, my lord.
forum
That after coming to know the facts, the petitioner and other villagers raised their objection regarding the non-payment of the compensation as against the forest right land for which the quota has granted by the district level committee, and in the meantime, without knowledge of the petitioner, other villagers cancel the forest right quota without giving any opportunity of hearing, my lord.
This expedition has been filed by the petitioner S.K.Sahoo Hon'Ble. Currently, the order dated 7/2024 passed by the collector general at annexure 7. The further there, the direction to the collector general of the party number 2 non-compensation of the petitioner for the upward forest land of the University Collector's land. The United Council for the petitioner bring the attention of this court to the instant order, wherein it is observed as follows. Quote this, the reserve to for natural industries. The land council for the petitioner submits that the petitioner has not been given any opportunity of hearing before passing of such order, and in that respect, he has taken argument in paragraph number 9 of the expedition. This will notice on the question of admission and saying that its matter shall be disposed of at the stage of admission. You are appearing for all the opposite party. Channel number 10.
Channel number 10. Some notice.
Manager, Managing Director, Orissa Coal
OCPL.
Power Unlimited. To you. Fortune Tower, 4th floor, Bhubaneswar. How did you? Right. The Land Council for the State Access Notice in the opposite party member of RTC. Relates for response of notice on opposite party member which discusses the limits of this time by Monday. By Monday. This matter 4 weeks after. Our affidavit in yes, question.
Publish.
Item 15.
May it please you, let's see. The paternal property's land has been acquired by the authorities, my lord, but the compensation has not been paid. My representation is at annexure 5, my lords. My lords. The collector will let's see. My lord, up to number 2, my lords.
Item 16.
1 pass 4, madam. 1 pass 4.
Item 17.
May it please you, see. So the petition of the landless person, landless person acquiring government land and cultivating this area in order to maintain his livelihood is filed the representation by the annex of 3 lots. 1 by 70. 18 plus. Publish.
Item 18.
May it please, madam.
When the land was acquired for lower Suktel irrigation project Balangi. Annexure 7. The petitioner said
Annexure 7.
Annexure 7 meter.
Item 19.
insufficient enforced
Bank service.
Bank of Boroda. Alternatively, may be available to dispose of net.
Item 20.
For disposal of grievance.
Grievance fiction for accepting grievance fiction that would be
Response to 19-119. By accepting the written statement filed by the petitioner in response to the letter dated 19-119 issued by the Secretary to Revenue Divisional Commissioner and all order pending.
Item 21.
Yes. 21. Presentation 6/3/2022 means annexure 6. Annexure 6.
Item 22.
The National Highway, the opposite party made copy solved. The similar order you will also pass the previous. Yes.
Mr. Amitabh Das
Name and reflected in this order. Mr. Amitabh Das. It is 23-24. Mr. Das, 23-24 state government.
23-29.
23 to 29.
29 and 31, 32, 36.
All right.
Next week.
Next week. Uh, 23 to 29. 31, 32, 31 to 33.
You will call 30.
Item 30.
The land of the petitioner, on the land of the petitioner, the opposite parties are constructing.
Your representation. Grievance petition.
We had filed representation. Last is the grievance petition.
Issue 5 to yes.
30.
30.
Item 34.
OGLS. The honorable postman. Certificate copy of improved orders. Proposal for exchange of land in support of encroached government land is rejected.
Page 34. The illegal occupation of the government land. Because in evidence and opposing the land exchange, but encroaching case have already been instituted against the petitioner. All good in view of law.
Item 35.
Pass over for item 30.
Did I pass over?
35 pass over. That is
Item 36.
Lordship covered matter in the same matter.
37.
36, 37, 66 and 69. 59.
67 and 69.
66, 69. 66, 69.
So, yes.
Item 38.
Judicial law, judicial officer, judge, family court symbol for
Item 39. Item 30.
39 my lord, I think 39 you are
Well,
Well,
this is the two cases, my lord, are the cases of judicial officers, my lord, working as ADJ in that category, my lord. The sole grievance, my lord, they should have been considered for pension being admitted to pension, old pension rule.
Just a minute, 38.
My lord, Satyanarayana Kar.
38.
The issue, my lord, has been settled by Ananda's case.
No, that is not applicable to you. Go through. That is not applicable.
Sir, I'm saying
Not even principle to you. Not even principle to you. You have not joined within that period.
no, my
You have
lord,
not.
in Ananda's case, my lord, the issue was when the process started.
No, that was not the
No,
case.
can you see, my lord, that
He had also joined before the notification of the government. Amended notification. Yes.
But so far this principle is concerned, my lord. Finally, my lord, the Honorable Supreme Court dealing with cases of judicial officers governed by SETI Commission and Padmanabhan Commission, my lord, have held that the state government notification is not applicable, putting that restriction. They should have been guided by that. And on that basis, my lord, exactly.
Guided by what?
There should have been.
The matter is still there in Supreme Court, sir. In always judges association is still there. They had again insisted for it. Supreme Court has not granted.
So implementation.
Now, if you are saying for SETI Commission and Padmanabhan Commission,
yes,
then the Supreme Court has not granted.
Yes.
So we cannot go by that. You come to this one only, whether it is in at par with Ananda's case.
Well, if you also look at the clarification issue,
because your candidature has been considered only after the de-reservation of the post against STSC. Prior to that, you had not been considered. So mere advertisement is not a matter of right to ask for that. You joined only after the notification was.
Reservation.
Yes. No, not de-reservation. De-reservation and after the amended notification of the government.
By the PSC. But if you also look at the judgment in Ananda's case, there, my lord, I have taken the specific ground, my lord. That when the process.
Notice.
With such and such player. Land council for the petition submits that his case is covered by judgment of Ananda. Ananda's a referential name. My daughter will get sponsor. This will not happen the question of only getting their response. The London Council for the state accepts notice on behalf of all the opposite parties. ଆପଣ ତ appear କରିବେ ନା ultimately High Court extra copies of the petition will solve all points. Matter will be listed after one page with the holiday it was that's of the minutes and the counter is running by the meantime. Yes, right.
That reference is 2004 supplementary 1 OLR.
Please give it in that urgency. Yes. And if you have got also the Supreme Court decision.
Yes, that I am reported. I'll just see. 38, 39, sir.
Yes, ma'am. The next item the same.
Yes, sir.
38, 39.
39.
Item 40.
You are there, Mr. Das? Item 22. You are not there.
Yes.
We have reflected your name.
But it is not similar matter. Earlier they have approached
Which item?
item 22.
22.
Yes, because earlier in those cases, my lord, they have approached the Honorable Court. There was an order pursuant to the order of this court. They have approached the project director.
They have to file this representation before you to dispose of that.
Yes, file it.
Yes. Password item number 40.
Item 41,
Same council password.
item 42,
Of BRSC.
Demolition without the process of device.
Your matter, Mr. Pani.
This matter, you actually see, they had under the National Highways Authority Act.
Yes.
Under the National Highways Authority Act, Manats, they had already acquired my portion of my land, Manats, in 2000, Manats.
National Highway Authority means Mr. Das.
Amitabh Das. I'll sir, have you saw the copy?
You are just here. Copy dena hai?
8, 9 to 10.
Basically, none of the allegations and
Yes, Mr. In his presence, we want. So he was just here. If he is not available, just serve a copy. We can take up day after tomorrow.
Great. I'll serve a copy. Put things in
place. A copy of the writ petition we served on Mr. Amitabh Das, who used to appear for National Highway Authority of India. Put up this matter on 10th years, 3rd October 2020. Yeah.
Great.
Mr. Subit, senior. Yeah.
item 43,
43 also same council, Shobhana Kumar. Also,
item 44,
44, Mr. Mahanti. You are there. Also,
item 45,
same council, also.
item 46,
46.
In this case, the initially petitioner was appointed as a junior clerk in the year 1984, and he was promoted to the rank of Najir, that is senior clerk, on 4/3/99. Thereafter, in the year 2002, petitioner was placed under suspension under contemplation of departure proceeding.
Yes.
Departure proceeding was initiated against the petitioner, and he was punished with a compulsory retirement. Your Lordship kindly see Annexure 1, page 14, my lord. Last 4 line, my lord. So it is ordered that he be compulsorily retired.
Annexure 1.
My lord, page 14, 1/4.
Page 14.
My lord.
Two paragraph ta puri
last 4 line, my lord.
15 row.
14 row.
14 row.
Last 4 line.
So it is ordered.
So it is ordered that he be compulsorily retired from the government service as penalty contemplated under clause 7 of Rule 13 of Orissa Civil Service Classification Rules 1962. The period of suspension be treated as such.
Thereafter, petitioner challenged the said order before this honorable court, my lord. During pendency of this writ petition, petitioner filed another application for pay fixation.
Right.
It has to go to other bench.
This matter before some other bench, which one of us? Yes.
Item 47.
Item 47, Lordship. Annexure 2 is pending before the OP number 2.
Annexure 2.
Lordship.
On the dispute of annexure is the witness.
Item 48.
Your Lordship. Similar matter of Lordship order under Annexure 6 running page 20. I have annexed.
6.
Annexure 6 running page 20.
Item 49.
May I please, Your Lordship? This is also National Highway Authority, and I will just indicate what are the illegalities.
No, please give a copy so that it
In fact, we have given it to Union of India. I have also indicated.
NHA has to be there.
NHA,
NHA.
So give a copy to Mr. Das. He was here just now.
He was here.
So give a copy, we can bring it on day after tomorrow. Then. Same order like in Mr. Pali's case, day after tomorrow.
Item 50.
Amitabh Das को ना भी जाएगा reflect कर और
Previous matter is he had also appeared in this case. Yes.
50. Yeah. Next.
Item 51.
The password you can register, madam. Password.
Item 52.
On item 62. Where?
Compensation. Poor land acquisition compensation.
Will be done to password.
Objection has been filed under Annexure 5. NHA. Compensation has been awarded and the objectors have already received it. So the present compensation amount may be awarded in favor of present objectors.
Objection to refer karibo
say NHA arbitrator or collector. This
password. Next.
Item 53.
Same password.
Item 54.
Kindly password. Item 50.
Item 55.
Set the password. Password.
Item 56.
Item note 56 on behalf of CK Pradhan. Next week anytime.
Item 57.
Grievance petition. Annexure 3.
Annexure
3.
Annexure 3 to
before Lord Supreme.
Item 58.
57.
Yeah, please, Your Lordship. I have a limited grievance. The opposite party 1 has failed to discharge its statutory obligation in disclosing the essay number 117 of 2022. The petitioner is out of his property.
You seek for early disposal.
Yes, Your Lordship.
So the other side has already appeared. In the essay number 117.
Yes.
You are the applicant in the essay.
Yes, Your Lordship.
The other side has already entered appearance.
There it is. There. There they have appeared. They were taking time every time.
Mm. 3 months for them from the date of production of the order.
If there will no legal order.
If there is no order, it
Item 59, let's read that.
Representation under 6. Under 6. Collector symbol.
Next year 6 is the representation to be established. 59, yes.
Item 60.
Next.
Item 61.
This petition is seeking direction against the district magistrate to dispose my section 14 application, which is at annexure 1. The district magistrate Sundargarh. It was the application filed on 1st November 2022.
22
which is মানে করোনা
instruction you have Mr. This writ petition has been filed by Tata Capital Housing Finance Limited. Direction to the opposite party. Number 1, that is district magistrate from collector.
Moved on to section 14. Moved on to section 14 of this.
Under section 14 of this FSIR 2002. The Land Council for the petitioner submits that the application has been made on 1/11/2022, but no order has been passed. Yes. That the Land Council for the state obtain instruction regarding the status of the application under an issue on court of this matter.
May I submit one thing?
After 3
May I submit one thing, my lord? Lordship can dispose of, like your lordship disposed of one case, identical matter, with a direction to pass within 6 weeks, my lord. Then
direction divorce
date may be fixed.
Yes, after puja holiday.
Obliged, lords.
Item 62.
I may please your lordship. No, this is a case under Surface Act, my lord. The opposite party number 6, not the petitioners, had taken a loan of rupees 14 lakhs and odd, my lord, from Utkal Gramin Bank, Sambalpur, my lord. And thereafter, he did not pay the installment, for which 13-2 notice was issued against him for realization of total outstanding. Against 14 lakhs, the total outstanding was 42 lakhs and some odd. Thereafter, he did not clear the amount, and proceeding was initiated.
You are guarantor?
I was never a guarantor, my lord. My humble submission is, my lord, it is a joint family property.
This woodland is joint family property. It was the consent of the joint co-persons were never taken before mortgaging the land. But the collector has directed to take over physical possession of the land, and thereby will be deprived of our valuable property. Though we have no
forum is available in council.
My lord,
Appropriate forum is available.
my lord, so far as section 14 is concerned, we will not be loaning. We will not be guarantor. This is the joint family property.
All those things before.
My lord, otherwise, your lordship will see the order was passed way back in 2022. Thereafter, the collector has been recently taken steps to take over physical possession. A suit is also pending. In the civil suit, my lord,
Item 63.
lordship will protect me to the time being, my lord.
I can seek protection there. Yes.
Item
They will be dispossessed, my lord. That is
63. Same council. Also, next.
Item 64.
Kindly taken up day after tomorrow. 64.
64 and adjournment. Yes, next.
Item 65.
Fair compensation, representation incident. Our order is according to Annexure 6, they will pass.
Annexure 6, the kings in the order for representation this way. Annexure 6 is a similar order.
Item 67.
Observer for similar on the order for initiation of arbitration under 3G5 of NH Act.
Similar order. Number to the 67 years.
Item 68.
Also,
Item 70.
Here be amount concern assignment of compensation or by collector. By collector only. Okay. Already passed. Already, yeah. In view of the above law,
So you take instruction on this. We have got already a favorable order. This petition has been filed with a prayer for a direction to the opposite party number 1. That is
land acquisition
officer and competent application officer. For recalculation and disbursement of compensation to the petitioner as per the order dated so and so by the learned arbitrator passed in ARV case number 95 of 2016 and 96 of 2016 of the stipulated. It appears from Annexure 1 that the arbitrator and collector pattern by order dated so and so passed in so and so directed the special land acquisition officer and competent authority so and so, but let the opposite party number 1 to recalculate the amount of compensation due to the petitioner as per the PUAD and to pay the differential amount within a period of 6 weeks. 6 weeks are long since passed, therefore, let the land council for the state obtain instructions as to why the order under Annexure 1 series has not been yet implemented as stated in the petitions. Put up this matter after finishing the yes.
Item 72.
This is at this point of the representation part. Annexure
3
in accordance with Annexure
4. Annexure 3
Annexure 6 Annexure 6 is very representation.
Annexure 4
ଅଛି
Annexure 3 ଅଛି Annexure 4 ଆମର order.
Item number 72 ତ
Sir.
ଆପଣ total ହଉଛି 4ଟା annexure ଆଉ annexure 6 କୋଉଟା ଅଛି?
ନାଇଁ Annexure 7 ଅଛି ଏଟା ତା ପୂର୍ବଟା ଆଉ ଗୋଟେ ଅଛି another
71
ହଁ,
72
ଏଟା ତ ଆମର 71 ରେ ଆମେ ଅଛି।
sir.
72 your matter.
ହଁ, ଆମର 71 is there which is 3 to be disposed of in accordance with 4.
9 10 संकेत पड़ेगी
ପଳେଇଛି ଆଚ୍ଛା then it is 72.
ये 72 कौन होगा?
Annexure 6 is pending before OP number 2.
6 with OP number 2 with disposed of. Next.
No, need time.
Time which kini match.
Item 73.
73 pencil correction or given the pencil
कर दीजिए
yes sir
लिख दीजिए number 73 करी
item number I have not mentioned but pencil correction I have given and connected matters also same also blessed
with अच्छी से same yes
Item 75.
My lord, I am on VC, Lordship.
what modification you want?
Lordship, modification of order dated 5/9/2021. Lordship, petitioner name is Rikulota Lenka. So, Lordship, and third paragraph, order number 2, third.
बोलिए शिल्पी दास ही
Lordship, and plot number, Lordship.
हाँ आओ कौन?
Plot number, Lordship.
Plot number ही बोली जी
Lordship.
अच्छा এটা देखिए modification कर देवे allow कर देवे in column number in paragraph number 3 the in place of Shilpi Das it will be read as Ritulota Lenka and
Lordship.
column number say paragraph number 3 in
Each line.
number so and so plot number so and so shall be read as plot number so and so है ना बाकी सब ठीक है ना
Lordship.
next आइए इस disclose now
Item 76.
yes कौन modification होगा Mr. Das आइए तो देख लो आइए number 1 for modification
To register the lease miscase via Annexure 1 and take follow-up action in terms of order passed to the
modification of the order to and directly your process now to register
lease miscase.
Lease miscase तो pending ଅଛି ବୋଲି କହିଲା
lease miscase 793 was pending. Why to register it again?
Clearly पुणे second ଦୁଇ ଥର ମଧ୍ୟ
Absolutely clear.
ନାହାନ୍ତି ଅଛି ପାସୱାର୍ଡ yes next
Item 77.
strong correction of again number 12880
Directing correction modification of the order dated 18/9/24 to the extent of the discrepancy as it appeared in respect of the khata number at page 4, last paragraph at para number 2, last line of para page 5 of the said order.
Khata number ଗୋଟେ ହଉଛି page 4 and 5
page 4
खाता नंबर कभी लिखा है तो 480 4 and 5 5 रे कितने ଅଛି
खाता number 480 plot number say 184 183 178 ଅଛି
हाँ से ठीक है बड़ा वाला इन 500 को
button item 54 sorry I was not there
500 order exam that's not
Pass over item number 16.
May I please, madam?
Yeah.
The petitioner had applied for conversion of his land
as per the scheme annexure 1, which says conversion fee is 5% prevailing rate in respect of the plot, construct as well as per the rate available at the time. Prevailing rate of the premium, that is it. He applied for the conversion law under annexure 2 on 11/11/2009 to along with all documents. Receipt is granted, page 18.
Please come to annexure 14, the inclusion order.
Minor. Inclusion order they say, you apply again the rate.
Just read it out. Page number 39.
Minor. Allowed documents, attested copies.
No, in inviting reference to the letter on the subject noted above, I'm direct. Please read it out.
Minor. Inviting reference to the letter to the subject letter, I am directed to say that your application for conversion fees at the old rate has been examined their threadbare. It is revealed that the individual plot has been allotted in favor of Ambika Prasad Guru in 1987 for residential purpose. The loans had applied for conversion on 11/2009. The lessee had not submitted the attested copies of the documents along with the conversion application. The reason for such delays in disposing of the matter is due to negligence on part of the lessee in furnishing the required documents. This is the order. But man can see page 24. Page 24. Now page 23.
Now, ଗୋଟେ କହୁଛନ୍ତି GA state portal ରେ ଗୁଡାକ ସବୁ ହଉଛି ଆଉ ସେଥିପାଇଁ ଆପଣଙ୍କୁ conversion fees ତାଙ୍କର
ଆଗରୁ ଆଜ୍ଞା ତାଙ୍କ ପାଇଁ ସି ପେଜ 23. My application is relevant 2009. Now they have allowed my application in way back in 2013. Page 24. The signature special secretary government, General Department, at the bottom, 17/2013, allowed. But they have calculated, instead of calculating the rate as prevailing rate of the application, they have calculated as per 6 crore 60 lakhs. I will find at page 23, 10% of 16/2013, column 15. Premium rate as per occur as on date of 16/4/13. My application was 11/2009, and the very moment in annexure 7, that was 2010, page 27.
What it will be further delayed.
But they already allowed that. Allowed a higher rate. They should allow the rate prevailing on the date of application.
Okay. Now, if you want to reduce that rate, they say that for that you have to, since the new portal has come, in that you have to make the necessary application.
Well, already it has been allowed. This is all mentioned in
the जो पेमेंट टा जो इची आपण पेमेंट को चैलेंज करछन सॉरी राइट सो ताकू कंसीडर करिया को हेले यू हैव टू अप्लाई इट एफरेस इन दैट न्यू पोर्टल जे आपण को फीस टा एटा को रिड्यूस करंतु बेली
मैं कहि दिला जोटा ऑर्डर देले अनएक्सपेक्टेड ऑर्डर देले दैट वाज बेस्ड ऑन रिप्रेजेंटेशन ऑफ 21/11/2013 with the answer 13 years. In all details here mentioning is you are allowed, already allowed. I could give us only that the rate that though their own answer says you should be at the rate of prevailing at the market. That's the application. Page 26. 26.
You have not also filed the attested copies of the document.
Well, they were allowed already. Once they allow the application to rate, fix the rate. How do I get the question of the attested copies? Considering the application of the document, they have allowed it and given the letter prevailing on 14 lakhs.
Where is that?
Madam. That the order notice order 7/2013 and 24 28th April, they have allowed it or given the order.
Please show us that.
Okay. ଆଜ୍ଞା ଦେଖନ୍ତୁ କୋଡ଼ିଏ 4 ଅର୍ଡରଟା ସାର୍ ହଉଛି annexure 9 plus 30.
Yes.
On the basis of the notice order, they have issued me order that pay this much of money. It's 30.
Annexure 9.
9 madam.
So what he said that you have to deposit a sum of rupees 14 lakhs
14 lakhs.
towards the conversion fees in
Madam.
the shape of bank draft
Madam.
drawn in favor of so and so.
Madam.
You have to execute a conveyance deed so and
Madam.
so and so.
Yes. So these are
Only the documents in support of your so and so.
Again.
So many things are required. This information were given to you. So have you complied with all?
Well, this 30 lakhs, calculate the rate of 30 lakhs per acre at that time on application. That they say that I have 14 lakhs. I am showing to my lab, I will kindly turn to their notice order in which they have calculated the rate at 6 lakhs, 6 crores, 50 lakhs.
So against that particular
Against this fictional high rate, I am
Annexure 9 you filed
representations.
कोठी कहाँ पर करें?
Detailed number approach कर चलनी several representations.
That is Annexure 13.
I have referred to 13 and see several representations I have made. Yes, to 35.
The latest one is Annexure 13.
13.
Annexure 15.
सब कुछ है
Annexure 15.
50 आता है representation बोले आउट है.
Is the reply.
Last page, madam.
That is after all this I have made the representation 13 14 director. No सुन ले परे. The principal is
ଏଇଟା ଏଇଟା କଣ ହେଲା 19324 ର ଲାଷ୍ଟ ଟା ଦେଇଥିଲେ
କିଛି ହେଇନି ପଡିଛି କରୁନାହାନ୍ତି କିଛି ନକରେ ମୁଁ ଆଗରୁ ଆସି So the principle of their principle
19324 representation is to be disposed of.
That can be done, but they will delay it unnecessarily.
That is to be disposed of by Annexure 15. We will take time limit.
Okay.
Yes. Next.
Item 34.
Multiple representation फिलहाल disposable.
My lord, more 19 था, lords. 19.
19 के से representation फिलहाल dispose of करियो. Yes, next.
Item 34.
My lord, it may be urgent for 1 week time. Inquiry has been certified couple of inquiry could have been certified.
After Puja holidays. Next.
Item 35. Here the petitioner is an auction purchaser, and while executing the deed of conveyance, stamp duty as well as registration fees has been collected, which is not supposed to be collected as per the mandates of Section 89(4) of the Registration Act, and as per the clarification of the state government, which is at Annexure 3, and as per the settled provisions of law of the Honorable Apex Court, so also this Honorable Court. Lordship may kindly have a glance at page 13 of my writ petition, wherein there is a clarification as to registration of sale certificate when the sale certificate has been issued to an auction purchaser. The same is to be the said sale certificate is to be validated and sent to the auction purchaser with a copy of the registering authorities to be filed in Book 1 as per Section 89(4) of Registration Act.
In Annexure 3, what you want us to see?
Lordship,
Clarification.
There's a clarification.
Oh.
Wherein the state government has clarified that as per the second point, Lordships may say, in the case of SJP MPEX, Private Limited versus the Assistant General Manager and the Authorized Officer Canada Bank, the Honorable Supreme Court has upheld that the sales certificate issued in favor of the appellant does not require any registration in view of 17(2)(12) of the Registration Act, as the same has been granted pursuant to the sale held in public auction by the authorized officer under the provision of SARFAESI Act. Further, the authorized officer under SARFAESI Act is to hand over the duly validated sales certificate to the auction purchaser with a copy of the registering authority to file in Book 1 as per Section 89(4) of the Registration Act. The Honorable High Court in WPC number so-and-so Sebati Tudu versus Authorized Officer Indian Overseas Bank and writ petition number 133 of 13376 of 2023, MS Padma Prabhu Commodity and others has also passed the orders in the aforesaid ratio.
So, state the collector to refund the money.
Collector, sub-register, as also the authorized officer.
This is to be disposed of.
This is to be disposed of.
Annexure 4 is to be disposed of. Is the information statement?
Number 25.
Annexure 4.
Item 40. Wait.
May I please? The petition of the Sonal Court challenging the order of the Central Administrative Tribunal. The batch matter or lordship already issued notices.
Other matter.
Matter. And directed the council for the union to take instruction. And the matter is posted to 2010.
Kana review.
The English are that in first.
Pass on the statement. Pass on the statement. Different matters, man. 41, 43.
No, think you. Kana review.
Other similar matter is item.
Just a minute.
Matter.
Similar order item 40
41
41
43
so issue notice 43 issue notice 51
madam 53
just a moment 51 then 53
55
55
63
63
and 68. The matter is posted to 2010. Initially it was posted to 24/9.
से item गुड़ा number गुड़ा
Madam.
63 item may be recorded for the central government.
60?
3.
63.
हाँ अपन को ऐसे ये
दे लेबे जी जा
जहाँ ना कोई भी मैं लिखी दूँगा पूछे अपन ना लिखाओ पूछे कहाँ ना लिखाओ just टिक टिक next
Item 44.
Yes.
My lord, the petitioner's residential house and land acquired by the my lord for construction of railway over bridge. So, my lord, as per the renewable circular, page 83. So, my lord, revision of policy regarding compensation of land users affected by land acquisition for railway project, page 83. So, my lord, previously up to 2019, there is provision for employment group D. So when the
representation
representation my lord, see, reject got the railway is saying that proposal should be submitted by the state government. Annex 23, the my lord secretary without not properly holding the inquiry pays 1 crore my lord. Annex 23. So my railway is saying that unless the proposal comes from the state government side, how will act upon the railway circular?
So railways means who is to appear for?
My lord, जो हमारा 8 का general number 3
ये appear करियो
तो इन्होंने
Union of India
Bimbisar Das is
Bimbisar Das copy उठे दियो
copy
next one
Mr. Sanjeev Tran. Sorry, Sanjeev Tran. Mr. Sanjeev.
Sanjeev.
So I send it.
Sanjeev.
ଗୋଟେ କପି ଦିଅ ନା
ଆଜ୍ଞା।
ସଞ୍ଜିତ ସ୍ୱାଇଁ ତ ଆମେ ନାଁ ଲେଖିକି ନେଇ ଆସୁଛୁ ନେକ୍ସଟ ୱିକରେ ଗୋଟେ କପି ଆଉ କୋଉ କନେକ୍ଟେଡ ମାଇଣ୍ଡ
ସାର୍
45 my name is
ଆଚ୍ଛା 45 ରେ ଆପଣ ନାଁ
Ganalok Mandishan.
ନାଁ ଗୁଡା ଲେଖି ଦେଇଦେଲେ ଅସୁବିଧା ଗୋଟେ ସ୍କ୍ରିପ୍ଟ ଲେଖି
ସାର୍
ସମସ୍ତଙ୍କର ଇଏ ଡେଜିଗ୍ନେସନ ସିଜିସି ନା କଣ ଅଲଗା
Sanjeev Rai and myself, senior panel councilman.
ଆପଣ ଲେଖିଦିଅ which designation ଟା ଦେବି next week next
Item 52.
Land acquisition proceeding, lordships. The section 4 notification, section 8 notification have been made. Subsequently, lordship kindly turn to page 40, annexure 4. Section 19(1) notification has been made, saying that my land has been land of the petitioners have been acquired.
କଣ ହେଲା compensation ପାଇନାହାନ୍ତି ନା କଣ
ନା ସେଥିରେ ସେ ଆସିକି କହିଲେ ଯେ ତୋର ଯାହା ଅଛି ଦିଅନ୍ତୁ ବୋଲି ମୁଁ annexure 5 ସିରିଜରେ ସବୁ ଡକୁମେଣ୍ଟସ ଦେଇଛି ଯୋଉଟା କି 15/4/2024 ପେଣ୍ଡିଂ ଅଛି
କିଛି ହେଇନି ତାପରେ ରେସ୍ପନ୍ସ କିଛି ପାଇନାହାନ୍ତି alright annexure 5 series to be disposed of
within a short time
3 months or from the date of production of the copy of this
it might be 2 months because 14/4/2024
alright give it 5 series to
diplomat
Item 54.
Made similar to the petitioner avail the cash credit facilities and avail a loan of rupees 40 lakhs and thereby he has been paying the interest 54 and petitioner has been paying the interest and the part payment of part payment of the principal amount regularly. My annexure 1 is the bank statement, but unfortunately without any considering my one-time settlement negotiation, he issued annexure 3, 13 to notice demand, make payment of 30 lakhs and some odd, and annexure 4 is the 81 position notice, my lord. My lord, the thing is that then the bank has approved the DRT for recovery of the loan amount 20 lakhs some odd, 20,64,057. Was filed the in DRT application, it is in defect to dive stage, not will has been registered. But I approach this High Court because the highest of opposite parties, being the bank deals with public money, with a public approach for growth of industries, trade and commerce.
You also approach.
My lord, the thing is that I am ready to pay the money. My lord, allow me for that time.
State Bank of India. Make a statement there and pay the money and get it.
And
actually, 13/4 has been issued because of RP has been declared. Bank has finally issued. He has remedied for the DRT for filing section 17 application.
And I am ready with money. Please not taking.
All right.
Allow me for that time. I will clear all the amounts.
Make a statement there. Yes.
And my lord, in the meanwhile, this will not take coercive action against the petition property. My lord, that much of security, my lord.
Number 16.
Origin certified copy.
16 May.
Here, my lord, my application 60. Here, my lord, earlier this honorable court directed for consideration of my application for allotment of a piece of government land for establishment of a school, and that has been rejected under annexure 7, my lord. That is under challenge. And the inquiry was conducted in my absence and without following the due procedure of law, and the inquiry report annexure 6, that is, my lord, it has not put for the correct facts in the inquiry report. Apart from that, my lord, if your lordship will peruse annexure 7, page 28, no hearing was conducted in presence of me. I was not noticed, and the order was passed on 31/7/2024, and the next page of lordship can peruse, the order was signed. The date has been put to 2nd August 2024, the last portion. I have never been had.
Annexure 7 जो पास होला पूर्व आपको hearing opportunity
No, man. No. 31/7 page 28 lordship can peruse. Without conducting any hearing, the order has been passed. The order itself reveals that no hearing has been conducted.
Just a minute.
And that is my specific ground of challenge. And the inquiry report also at page 26.
ये जो 31/7 order pass ହେଲା कौन ପାଇଁ ଆପଣଙ୍କୁ
They have rejected my application.
no that is rejected the ଏଟା କौन ପାଇଁ ଆପଣ କौन ପାଇଁ apply କରିଥିଲେ
For allotment of a piece of government land on lease basis or on the OGLS Act for establishment of a school.
the application filed by Krishna Chandra Swami, President.
Yes, ma'am.
Indian International School for allotment of the following schedule of so and so. Register the case as so and so. Ask record keeper for verification. RI concerned directed to cause so and so. Trace map action.
2018 application, it was registered in 2024 after direction of this honorable court.
It's all right. Then register.
Page 29. Second paragraph. Since acre 9.562 decimal land has been relinquished by Water Resource Department to relocate government offices affected by development of SCB, Medical College, Kotak, and as per L number so and so, the Director Almi application form 1A has been applied by the requisitioning authority which are pending. So the said land cannot be leased out in favor of the said organization, and the case is disallowed and the applicant case is disposed.
So under what right you expect this once it is rejected?
There is a government circular.
What is that?
For allotment of lands, government lands in favor of educational institutions.
No, but
extra land is there, and now the land
duty chahibe kon city paibe.
No, that I am not.
For a land which will be
that I am not saying, my lord. What 2000
particular plot ସେଗୁଡାକ ଦେଇଛନ୍ତି ସେମାନେ ଦେଖେଇଲେ ଯେ ଏଟା SC ପାଇଁ already
ଏଇଟା ମୁଁ ଯେତେବେଳେ when I applied my land in 2008, that land was not allotted to SCB.
Larger interest.
ଆପଣଙ୍କର ultimately 24 ର situation ହଉଛି ଏଇଆ ତେଣୁ if you file a fresh application that ମତେ provide କରନ୍ତୁ ଯୋଉଟା କି acquire ହେଇନଥିବ এটা SC medical college ପାଇଁ already acquire ହେଇଗଲାଣି ଆପଣ ସେ ଜମିଟା କେମିତି ସେ ଦେବେ
ଏଇଟା SC medical ପାଇଁ acquire ହେଇନି ସେ କହୁଛନ୍ତି SC medical college ପାଇଁ acquire ହେଲା ବେଳେ land ଯୋଉଠୁ office ଗୁଡା displace ହେଇଯାଇଛି so let me take instruction whether any other land is available in that area
that you are free
I'll file an affidavit to that.
The requisition has been filed with so and so after going through the improved order we find no informative in this and according to this yes let
the Lordship grant me liberty.
Petitioner is at liberty to make a fresh application for the allotment of the government land, which should be considered in accordance with law. Yes.
No.
Item 76.
So, what is the modification? Non-appeals for imagine after Puja holidays, repeated for like
Item 77.
Same after Puja holidays on repeated for non.
Item 78.
No, please. Last again, my lord.
I believe my learned friend was over. Question of proportionality of punishment.
Yes, ma'am. First again, I have cited 6 judgments. And today morning I have handled 4 reviews. Before going to the propositions matter, I want to go to page 151 matter of the order passed by the tribunal, first order matter. Paragraph 17.
Page
341 of the brief. So far as the question of natural justice is concerned, at para 17, the second point, I got it. The second point is whether the respondent have conducted the disciplinary proceeding by following the due procedure of rules. It is the case of the applicant that there has been violation of procedure while conducting disciplinary procedure against him. However, the applicant
এটা ফার্স্ট অর্ডারটা সেটেলমেন্ট ହେଲା ତାପରେ ପୁଣି ଗୋଟେ ଫ୍ରେଶ ଅର୍ଡର ପାସ୍ ହେଲା
first order to matter this honorable court remitted back the matter.
Yes.
Only the ground of delay in pronouncement of judgment. And this honorable court also has not gone to the merit of this case. It is clearly reflected. So let's tell facts and circumstances how the learned tribunal had traversed jurisdiction that I am pointing out to your lordship. So firstly, the tribunal held that there is no procedural access or violation of natural justice. Therefore, I want to
first order was passed.
First order was passed on 37 2019.
তারপরে সেকেন্ড অর্ডার
Second order
11/5/23.
11/5/23.
He might have gone wiser in the by passage of time.
No, I will show you lordship.
ଯୋଉ ଜିନିଷଟା 2019 ମସିହାରେ ତାକୁ ସେ ଇଏ କରିଥିଲେ ତା 2023 ରେ ତାପରେ ଗୁରୁତ୍ୱ ଦେଇକି ସେ order has been set aside, so you can say that
only manner this honorable court directed the compliance of 105 rule 105 manner. So, however, the applicant has not.
I don't intend to interject, my lord, but your lordship had stated they had this point was already argued. Stated that I'll make my submissions. This was
ଆପଣ ସେ କାଲି ନା କଣ ଏଇଟା ଥିଲା ବୋଧେ ଆପଣ ସେ କହିଲେ ଯୋଉ only on the ground of ସେ ଯୋଉ punishment ଉପରେ ଆପଣ
punishment ଦେଖିଲେ ଏଇ ପଏଣ୍ଟ ଟିକେ ନ ଦେଖିଲେ
ହେଇଥିଲା ପରା କାଲି
ଟିକେ ନ ଦେଖିଲେ ଟିକେ ଅସୁବିଧା ମୁଁ ଦେଖିଦେଉଛି
ଆପଣ କହିଥିଲେ ଆସିଲେ
କ୍ଲାରିଫାଇ କରିଦେଉଛି ଫରେ ନୋଟିସ୍ ନା ମୁଁ ସେ ଡିଫରେନ୍ସ ଖାଲି ଦେଖେଇଲି. However, the applicant has not specifically brought to the notice of this tribunal as to the alleged procedural irregularities by which he has been prejudiced. Further, the applicant has taken a plea that the advice of UPSC, based on which punishment was imposed, having not been communicated, calling upon him to submit his written recommendation, there has been a violation of the principle of natural justice. It is to be noted that we don't find any here either in written brief submitted by the applicant to the disciplinary authority or in the review petition or in the present way any such ground to have been taken by him requiring the respondents to effectively counter the same. In absence of any such point raised beforehand, thus facilitating the respondents to defend their action, it would not be proper for the tribunal to take cognizance of the same at this belated stage. We also don't come across non-observance of the principle of natural justice, which has resulted in defeating the course of justice in the instant case. It is not a case where recording of statement of witnesses has taken place in absence of the applicant, nor the witnesses whose statement was relied upon by the disciplinary authority to initiate disciplinary action was examined in absence of the delinquent applicant.
applicant has moreover pleaded that the charge leveled against him doesn't disclose any misconduct and therefore the same is void. The Honorable relied upon Nandkishore Prasad versus State of Bihar.
These all
And
have been met with. These are all have been met with. It's only.
Kindly wait. Let me submit.
You made all the arguments again.
No.
It's only.
I just point out the lordship has the difference in the previous judgment and thereafter thereon. Same point, my lord, he has traversed when his jurisdiction and hold that the principle violation of principle of natural justice. And thereafter, para 19. Having heard to the fact and circumstances of the matter, we are of the opinion that this is not a case where the applicant has been imposed punishment based on no evidence, and therefore the imposed orders passed by the respondent don't warrant interference by this tribunal. And hence this is.
No, the same presiding officers have traversed the order.
Yes, ma'am.
Same presiding officers. Was there any other fact brought before the court?
Lateral, no.
Self-same document.
Yes, ma'am.
Only the judgment was to pass to the
Yes, ma'am. Thereafter, mother, and this honorable court's order, I also point out that for this honorable court observed. In Malad Para 9 of this honorable court's judgment, page 368. Page 368, Para 9. In view, my place. In view of the factual matrix, as mentioned above, and also the rival contentions raised by the law and counsel for the parties, by relying upon their respective judgments, the matter is remitted back to the Central Administrative Tribunal, Cuttack, for its re-adjudication by giving opportunity of hearing to all the parties. Needless to say that this court has not expressed an opinion on the merits of this case itself, nor has given an opportunity to either of the parties to add any other document. Rather, the matter shall be decided on the materials available on the record itself, and the order shall be passed strictly in compliance of Rule 105 of the 1993 rules. Since it is an young case of 2008 and in the meantime 14 years have been passed, the petitioner has been deprived of getting his pension benefit. Because of the order passed by the National Authority, the tribunal shall make endeavor to dispose of the matter as per preferably within a period of 3 months.
Are you
This is the direction.
not aware about so many judgments? Same judge has taken a view in the Honorable Supreme Court.
Yes.
After some years on the same principle, they have taken another view.
Here in this case, my lord, the preservation is same.
See,
Same judge. And the thereafter, my lord, what order has been passed.
Similar अन्य view नहीं by passage of time interpret କରୁଛନ୍ତି ଏଠି full opportunity ସେମାନେ ଆପଣ କୋର୍ଟ ରେ ଦେଇଦେଲା କୋର୍ଟ କହିଲାନି ଯେ ଖାଲି ଯାଇକିନି ଏଠି ଗୋଟେ ରବର ଷ୍ଟାମ୍ପ କରି ଡେଟ୍ କରି
ନା opportunity
ଦେଲା ଫିଙ୍ଗର ପ୍ଲେସ୍ କଲେ ପାର୍ଟି ପ୍ଲେସ୍ କଲା ପରେ କୋର୍ଟ ଆଡଜୁଡିକେଟ କଲା ଏଇ ଯୋଉ ସେକେଣ୍ଡ ଆଡଜୁଡିକେସନ ରେ ଯଦି କଣ ଭୁଲ ଥାଏ ଆପଣ ଆଗରୁ କରିଥିଲେ
ଫାର୍ଷ୍ଟ ଅକେଜନ
ପରେ ପୁଣି
ଫାର୍ଷ୍ଟ ଅକେଜନ ମାଇଲର the learning tribunal held that there was
no meaning of giving due opportunity. When the opportunity has been
in the first occasion, my lord,
not like that.
Was also given.
And this
because the matter was remitted back. So this
the point which might not have strike or might not have appealed at a particular point of time after 4 years, he might have gone through some. It's a change of process. Mental process that it goes from time to time. You cannot say that what view I have taken in 2014, I will take here now at this. So many
385. On that point, matter
changing scenario. There are
yes,
also in that.
He has the tribunal held that as the advice of the UPSC has not been tendered to the petitioner, that is the violation of natural justice. But at that period, in the previous judgment, this fact has not at all been pleaded in the way in the review filed by the applicant before the review authority. So also in the appeal, he has not pleaded anything. So also
that you can say.
So also not in the way also.
That is the ground you can say.
That is
Yes,
that
ma'am.
ground.
Yes, ma'am.
Hartford see again you can say that the ground on which the fresh order was passed, this particular ground was not taken either in the original application, not so that can.
That is a ground you can say.
It is one of the grounds. UPSC, advice of the UPSC. And so far as the natural justice is concerned, he has explained in previous judgment, he hold that all procedures have been maintained and he has given due opportunity. But in the second round, while he passed the impugned order, but he held that there is violation of natural simply.
After hearing everything from you, my esteemed brother put a pertinent question about the punishment.
Yes.
So that
I am going to that punishment back. Then what my lawyer was citing that updated judgment, my lord, Ramlal. It is not applicable to the present case as because, my lord.
No, that you are going again on the merit.
No. এটা খালি কହୁଛି ତାଙ୍କ ରିପ୍ଲାଏଟା ଏଟା ଆପ୍ଲିକେବଲ ହବନି ଇନ୍ ଦ ସେନ୍ସ
ଆଚ୍ଛା
ଏବେ ସାଇଡ୍ କଲେ ନା ସେ ଯାଉଛି ରାମଲାଲଟା ଖାଲି କହିଦେବି ଏଥିରେ there is a judgment I have given to your lordship, my lord. The 5 constitutional bench judgment that has not been taken into account in this case. But I have given first case Sheikh Akbar Ali. This is our High Court petition judgment, my lord. It is Honorable Justice R.K. Patna and Honorable Chief Justice, my lord. Wherein at para, my lord, 9 they have dealt with Hensing. Wherein and last part. No, my lord. Para 6, 7. Para page 7. Para 9 continuing. The accused is said to be fully acquitted of from the top 1, 2, 3, 4, 5, 6. From the top 7th line, madam. Page 7.
Page 7, 7th line. 7th.
Yes, ma'am.
Comma ru arambha kori.
Yes, ma'am. The accused is said to be. The Supreme Court in RBI versus Bhupal Singh Panchal 1994 1 SCC 541, and in that case it was held that mere acquittal does not entitle an employee to reinstate in service, and the acquittal has to be honorable, which means the accused is said to be fully acquitted of blame and exonerated, and the aforesaid decision was also quoted in approval of Hensing. And para 10, referring to the decisions discussed herein above, the court is of the view that notwithstanding an order of acquittal which doesn't fully and completely exonerate the delinquent from a criminal charge, it would not entitle him to claim that the disciplinary proceeding should be dropped, or for that matter, the punishment imposed as a result to be set aside. The terminologies such as ordinary acquittal and honorable acquittal, as observed by the Supreme Court, have emerged from judicial pronouncements in case where the court records that the accused has been falsely implicated and that there was absolutely no evidence to connect him to the crime, then it is treated as an honorable or clean acquittal. However, if
for various reasons such as lack of evidence, benefit of doubt, prosecution witness turned hostile, or star witness resiled during trial, it would only result in an acquittal and not acquittal honorably. There is no tenebrosity in the settled principle of law that if there is acquittal on certain grounds like benefit of doubt, etc., from the charge of an offence involved moral turpitude, it would not automatically entitle exoneration from the disciplinary action. Directional para 11. Apart from the above, the degree of proof in a criminal prosecution is much higher than in departmental proceeding. It is settled law that strict burden of proof which is necessary to establish guilty in a criminal court is not required in a disciplinary proceeding where preponderance of probabilities is sufficient. At times, it is difficult to assimilate and put forth clean evidence in order to establish the prosecution case, which often results in acquittal, whereas in departmental proceeding, the standard of proof is different, which is based on preponderance of probabilities, unlike beyond all reasonable doubt. Therefore, even when a criminal case ends in acquittal, which could not be on account of various reasons, not being an honorable exit, unlike to impact either the continuation of the disciplinary proceeding or its outcome. If a disciplinary proceeding finally results in establishment of charges leading to imposition of punishment, it cannot be tinkered with on the ground that the delinquent had an acquittal in criminal case unless such acquittal to be full and absolute exoneration. In so far as the present case is concerned, the complaint was examined and also other witnesses during the disciplinary proceeding, and considering the entirety of the materials, OP4 imposed the penalty, accepting the finding of the inquiry. In GR number 845 of 995, the complaint was also examined. Besides, good number of witnesses, but the criminal court was disinclined to accept the evidence for reasons such as the person could have committed the overtax in presence of other officials of the PS, and for the fact that the lady staff did not disclose the alleged incident to her neighbors, etc. Rather, the court accepted the evidence of the petitioner, which is in contrast to the claim of PW10. Another employee of the PS, the brother and sister-in-law of the informant to whom she had disclosed the incident, were not examined from the side of the prosecution, for which the court held that it was quite unusual or her part not to share it with anyone staying close by till was disclosed to the family members. The handwriting expert was also not examined, and interestingly, the exhibit which was produced before the court was related to a different case. Under the above circumstances, the acquittal of the petitioner, according to this court, is not an honorable acquittal and is rather exonerated by extending the benefit of doubt. Para 12. It is reiterated that an acquittal which is due to want of evidence is not an honorable acquittal. If after full consideration of evidence, the same is disbelieved and the prosecution said to have miserably failed to prove the charges, or it is held to be false case, or neither to be a false case nor acquitted on the ground of benefit of doubt, under such circumstances, an acquittal may have to be held as honorable or acquittal of all blame. Even after considering the entire evidence, when it is totally disbelieved, it may be possibly be said an honorable acquittal. In the case at hand, though the court in the this is the thereafter manner. Para 13. The petitioner's defense heavily depended on the judgment of Supreme Court in GM Tang case, Supra, stating that when a criminal court on the same set of facts and evidence acquitted him, the punishment in the disciplinary proceeding cannot be sustained. On a sincere reading of the aforesaid judgment, it would reveal that in that case there was no iota of evidence found and proved against the delinquent, who had been dismissed from service via disciplinary proceeding on the allegation of having accumulated excess income by way of gratification, and as against such a background, the Supreme Court held that acquittal being an honorable one on the same and identical set of facts and evidence, the order of dismissal cannot be allowed to stand. The decision supra is not an authority to subscribe that even in case of ordinary acquittal, the disciplinary action not to lie or the punishment to die down naturally simply on the ground that both the proceedings are based on same set of facts and evidence. In the aforesaid decision, the order of dismissal was interfered with for the reason that, considering identical facts and evidence, there was an honorable acquittal, and as such, the distinction which is usually proved between the departmental and criminal proceeding on the basis of approach and burden of proof would not therefore be applicable. To succinctly put forth, the decision in Jim Tang case rather reaffirms the view that punishment in disciplinary proceeding cannot be allowed to stand when there is a case of no evidence with a resultant clean acquittal. Thereafter, the decision which I was firstly referring, that was Supreme Court of State of Orissa versus Vidyabhushan Mahapatra. This is a full-bench decision matter. In Ramlal case, which was cited by my learned friend earlier, I was submitting that this case will not be applicable as because this decision has not been taken into account. This decision still holds good, my lord. This 5-bench decision, Vidyabhushan, wherein, my lord, the sub-register has been proceeded with for receiving gratification and for accumulation of property, disproportionate property matter, wherein para page 2,
Supplemental list, item number 1.
Pardon, my lord. My lord, I am VC, my lord.
Here.
My lord, I am moved for bail, appellant number 3, my lord, who is the wife of appellant number 1, my lord. My lord, case is, my lord, on 2/3/2015, the date of occurrence, my lord.
No, just a minute. You are moving for bail of IA number Rajini Panda.
Yes.
C is appellant number 3. Appeal the watch. Since when you are in custody?
My lord, he is in custody. My lord, 5/3/2015, my lord.
What a sound.
कौन तैयारी जो 18 से जो ये
କଣ ହେଲା ଏବେ କଷ୍ଟଡି କେବେ ଅଛନ୍ତି?
My lord says 6/3/2015 dying declaration was recorded by the executive magistrate. Thereafter he was arrested.
6/3/2015. So you are not on bail during trial?
No, my lord.
Okay. And before this court, this appeal was filed in 2022. You have your bail application was never rejected.
Yes, my lord, this case is transfer free, my lord. I have moved a bail appellant number 1. Honorable Court of
That's all right. Appellant number 1, they have been released on bail as it appears by order dated 15/7/2024. You have been.
Yes, my lord. But he is not released because, my lord, his health condition is not well, and all family member is in jail custody. That's why, my lord, I have filed the wife of appellant number 1 to release, my lord. He is also lady and staying in jail custody, my lord, near about 10 years ago, my lord. That, my lord, file to release the appellant number 1, my lord, I have filed this case, my lord.
Appellant number 1 was what is his name? Ramachandra. Ramachandra. Appellant number 1.
Now he is in custody.
No, we understand.
Obligement.
So, is there any difference between this appellant number 1, whom we have already directed to be released on bail? Of course, he is now in judicial custody because there is no other family member. So,
the same thing will happen to this petitioner also.
No, why? କହିଲେ ପରା ସେ ବୁଢାକୁ ଇଏ କରିବାକୁ କେହି ନାହାନ୍ତି, ତେଣୁ ସେଇଥିପାଇଁ ସେ ବାହାରିନି। ସେ କହୁଛନ୍ତି ଯେ ଇଏ ବାହାରିଲେ ରଜନୀ ହଉଛନ୍ତି ରାମଚନ୍ଦ୍ରର ସ୍ତ୍ରୀ, ବାହାରିଲେ ଇଏ ତା ଯତ୍ନ ନବ ବୋଲି ସେଇଥିପାଇଁ ସେ ବୁଢାବୁଢୀ 2 ଜଣ ଯାକ ମାନେ ହଁ ସେଇଆ ହିଁ କହୁଛନ୍ତି। Let him go. 9 ବର୍ଷ ରହିଲାଣି। 6th heard the Learned Counsel for the is an application for bail of appellant number 3, Rajani Parida. Learned Counsel submits that the petitioner was taken into judicial custody on 6/3/2015. Finally, it was declared. Check karo final control. Rajani ro bhar kare. Rajani. ठीक है. 6/3/2015. And he was never released on bail either during trial court. He was never released on bail in the trial. He further submits that the husband of the petitioner has been directed to be released on bail by this court as per order dated 15/7/2024 in IN number 10 of 2024. And the petitioner is similarly situated, and since he is a lady, in view of the period of detention, the bail application may be favorably considered. Learned Counsel for the state submits that the petitioner is the mother-in-law of the deceased, and she has been implicated basing on dying declaration of the deceased, and it's a case of burn injury. However, submit that similarly situated. The petitioner is similarly situated like her husband, Ramachandra Parida. Considering the submission made by the Learned Counsel for the respective party, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, and since similarly situated co-accused Ramachandra so has been released on bail and inclined to release the petitioner on bail allowed. Yes.
Weekly list for others. Item number 4.
Next.
Item 5.
I Vachandi. Yes, Mr. Jafarullah.
That is a double murder case. So due to Millet, actual behind the case is the witchcraft Millet and the petitioner, the appellant. He is the Millet, the nephew of the deceased Millet. His younger father and mother. Aunt and his uncle. He has committed murder and
You are in custody since when?
since 2008, September 2008.
2008.
So
Let's get the final contact.
earlier my application was rejected in the year 2017.
Yes. Yeah, CORAM. କୋଡ଼ିଏ 9/2008 ବେଲରେ ନଥିଲେ ଆପଣ ଟ୍ରାଏଲ
ନାଇଁ ଟୋଟାଲି କଷ୍ଟଡି
କେବେ ରିଜେକ୍ଟ ହେଇଥିଲା ଆପଣଙ୍କର
2017 ହେଲା
5/4/2017 16 ବର୍ଷ ହେଇଗଲା Are the land council for the petition, land council for the state? The land council for the petitioner submit that the petitioner was taken into judicial custody on 29/2008 and he was never released on bail during pendency of the trial. His bail application was earlier rejected by this court by order dated 5/4/2017 and thus the petitioner has remained in custody for more than 16 years. It is submitted that the paperwork has been prepared but there is no chance of early hearing. Therefore, the bail application may be favorably considered. Land council for the state, on the other hand, opposed the prayer for bail and submitted that it's a case of double murder. And eyewitnesses such as
yes madam PW1 and 2
and there are eyewitnesses like PW1 and PW2 who have stated about the appellant committing the crime. Considering the submission made by the land council for the respective parties in view of the available material on record, while not inclining to release the petitioner on bail on merit but taking into account his period of detention in judicial custody, we are inclined to release him on interim bail for a period of 3 months. Baki usual order for the all right. File the surrender certificate and report of this action.
Item number 6.
Wait, please, Your Lordship. Petitioner has been in custody since 26/4/2009, Your Lordship.
26/4/2009.
Yes, Your Lordship. He was released twice on interim bail for a
last time केवे ଯାଇଥିଲେ এই কোর্টରେ ଯାଇଥିଲେ ତ
no, Your Lordship. 2017, Your Lordship.
No, this court has
Yes, Your Lordship. This court has
2017 last time ଯାଇଥିଲେ
yes, Your Lordship. For 15 days on the account of
5/9/2017
yes,
right interim bail revision अच्छा 15 days ଯାଇଥିଲା
ଆଜ୍ଞା
ଆଉ ଗୋଟେ ଥର କଣ କହୁଛନ୍ତି
on account of death of mother, your lordship, again for 15 days.
5/9/2007 ରେ 15 days ଆଉ ଗୋଟେ ଆର ଅର୍ଡରଟା କେବେ
Lordship, in the I don't have the exact date, your lordship.
okay I have a
2000, it is 17
that is 28/3 28/3/2017
yes, your lordship. Miss case 488.
ମା ମରି ଯାଇଥିଲେ ବୋଲି date of custody is 26/4/2009
yes, your lordship.
And also in COVID period,
He was on bail.
yes.
କେତେ ଦିନ ଟୋଟାଲ ରହୁଛି
Total hochi 1 month 28 days. 13 years, 1 month 28 days on today.
as per the custody certificate
Yes.
single murder
Yes, your lordship.
judgment hotel ମାରିଲେ
Yes, your lordship. PW1.
right side neck eyewitness ଅଛନ୍ତି
Yes, your lordship.
PW1
PW1 ହଉଛି eyewitness
Eyewitness, your lordship.
PW4 ହଉଛି doctor
PW4 is doctor, your lordship. PW1 is one eyewitness and PW5. ଗୋଟେ ବ୍ଲୋ ରାଇଟ୍ ଫେସ୍ ରେ ଅଛି
cervical
chest ରେ ଅଛି ଗୋଟେ ଫାଷ୍ଟ ନେକ୍ ରେ
indiscriminate
ରାଇଟ୍ ଇୟର ଟା ଶବ୍ଦ ହେଇଯାଇଛି lower end ରୁ fracture ଅଛି cervical vertebra fracture of are the learned counsel for the petition or learned counsel for the state a date that ठीक है तो फायदा हम करें learned counsel for the petition was Sabhatile. The petitioner was taken into judicial custody on 26/4/2009. He was never released on bail during pendency of the trial, and he was during pendency of this appeal. He was granted bail for 15 days on 28/3/2017 for the first time, and again on 5/9/2017 for the second time.
5/9 or 5/4/17?
5/9.
5/4/17 to 19.
Period the order dated order ହଉଛି 28/3/2007 ଆଉ ଏଟା ହଉଛି 5/9/2017 and since he has remained in custody for more than 13 years and there is no chance of early maybe if their application may be favorably considered. Learned counsel for the state has produced the custody certificate of the petitioner, which indicates that the petitioner has remained in custody for more than 13 years. The custody certificate is taken on record. The learned counsel submits for the state submits that PW1 is an eyewitness to the occurrence, and the evidence of the doctor PW4 who has conducted the post-mortem examination indicates that the petitioner has dealt number of blows on vital parts of the body. Considering the submission made by the Land Council for the respective parties, in view of the available material on record, while not inclining to release the petitioner on bail on merit but taking into account the period of detention in judicial custody and the conduct of the petitioner in surrendering at right time after availing interim bail on 2 occasions granted by this court, we are inclined to release the petitioner on interim bail for a period of 3 months. Yes, next.
Much obliged, Judge. Item 7.
Applicant custody since 21/8/2009.
Yes,
He has not supplied the deposition copy.
7.
कितने नंबर कितने लिखे बोलते हैं
Item 7, Your Lordship.
7.
केबे तो अच्छा लिखो जी
21/8/2009.
21/9
Not division.
2000.
No.
So what is the allegation against you?
My lord, single murder, my lord.
What you have done?
My lord.
Snatched away a spade which deceased was holding from his backside, and deceased fell down. Thereafter, accused gave 8 to 10 blows. Acha.
In
PM examination 6, Dr. Abhijit, page number 3. Lacerated wound, right ear, lacerated wound, parietal bone, fracture of skull, fracture of size, left temporal, all chapter blow achi. All the injuries are antemortem. Cause of death was due to vital organ. Acha. 2009 ହେଲେ ଆପଣଙ୍କର 15 ବର୍ଷ ହେଇଗଲା.
Earlier rejected.
କେବେ ରିଜେକ୍ଟ ହେଲା?
My lord, 31/10/2014.
31/10/2014. Are the Land Council for the petition, Land Council for the states. The Land Council for the petitioner submitted that the petitioner was taken into judicial custody. Final form that out is check on that. Custody on 22/8 IC 22 ତୁଳ ଗୋବିନ୍ଦ ତ ଇଏ
ଆଜ୍ଞା
ତ 22/8 ଭୁଲ କହୁଛନ୍ତି ଡେଟ୍ 22/8/2009 and thus he has remained in custody for more than 15 years and there is no chance of early hearing that we appeal and therefore the bail application may be favorably considered. Land Council for the state on the other hand opposed the prayer for bail and submitted that who is the eyewitness?
We have not.
His wife.
PW2.
Deposition कब भेजा नहीं?
Reject बोलता हूँ मेरे
এটা the wife थी over there.
Wife is there.
Because he was present at the time of
My
incident.
lord.
PW2 Jatri Patra.
My lord. And some of the villagers.
Now PW2 3 4 भी eyewitness.
4 yeah, 9.
Submitted that PW2 3 4 are the eyewitnesses.
And 9, your lordship.
And 9 are the eyewitnesses of and moreover the doctor Abhijit कितने doctor
PW7.
PW7 Dr. Abhijit Kumar examined conducted postmortem examination over the dead body and noticed as many as 4 external injuries on the vital part of the body and the cause of death has been opined to be injury to the vital organ like brain. Consider further submit that the bail application of the petitioner was earlier rejected on merit as per order dated 31/10/2014. Considering the submission made by the Land Council for the respective party in view of the available material on record, while not inclining to review the petitioner on bail, but taking into account the period of detention in the subject and absence of any chance of early hearing, 3 months bail granted. Yes.
Highly grateful.
Item 8.
May I please that Lordship, I have called for my letter, Lordship called for the custody certificate.
ଆଣିଲେ କି କେତେ ଦେଖଉଛି?
ହିସାବ କରୁଛନ୍ତି
12
ବି ଷ୍ଟାର୍ଟ ହେଇଛି 12/2012
Yes, ma'am.
13/2/24 ରହିଲା ତାପରେ ପୁଣି ଲାଇଫର ହେଇଗଲା 14ରୁ ଏତିକି ତାମାନେ ଏଇଟା ପିରିୟଡ ଟା କଟିବ
More than 12.
2 ବର୍ଷ କଟିବ 2 ବର୍ଷ କଟିଲେ ଇଏ ହେଲା 12 ବର୍ଷ 12 ବର୍ଷ ହେଲେ 12 ବର୍ଷରୁ ମାଇନସ କଲେ 10 ବର୍ଷ କେତେ ମାସ?
ସେ ବେଲରେ ନଥିଲା
ନାଇଁ ବେଲ 2012 ରୁ ଥିଲା ବଟ୍ କୋଭିଡ ପିରିୟଡରେ 2 ବର୍ଷ
ପେରୋଲରେ ଥିଲା 2 years
2 years ଥିଲା ଯେତେବେଳେ କୋଭିଡ ହେଲା ତେଣୁ ଆପଣଙ୍କର ହଉଛି 10 years ଆଗରୁ ମେରିଟରେ ରିଜେକ୍ଟ ହେଇଛି
ଥରେ
କେବେ
11/11/2014
11
and 13/1/2015
ଦୁଇଥର
13/1/2015
yes
looking to the relationship between the appellant and the deceased being husband and wife and the injuries sustained by deceased କଣ ହେଇଥିଲା ରେଜିଷ୍ଟର ଯାଇଛି
and that is 22/2/2016
ଦୁଇଥର ଯାଇଛି No, he is the principal.
It's my husband.
100% born injury. Husband or?
There is no direct mallet evidence. Allegation, page 17 mallet, and the trial court hold that being present, he has not tried to save her life. But other witnesses have stated the petitioner has carried.
Heard the Land Council for the petition, Land Council for the state. The Land Council for the petitioner submits that the petitioner was taken in the judicial custody on 24/2012, and his bail application has been rejected by this court on merit price. That is all by the order dated 11/11/2014, 13/1/2015, and 22/1/2016. And since the petitioner has remained in custody more than 7 years, and there is no chance of the hearing of the appeal, and paper has also not been prepared with their application may be favorably considered. Land Council for the state has produced the custody certificate, which also indicates that the petitioner has remained in custody more than 10 years. Considering the submission, nature of evidence available on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial proceeding and absence of punishment. So 3 months interim bail is granted.
Too late.
Item number 9.
May I please, Lords? My Lord, custody since 23rd December 2010.
23rd
December 2010.
2010.
Lord, I am filing an IA for bail, my Lord. Today I am filing, my
That was stay regulation of time payers.
Lord. I am filing for bail today, my Lord.
Aguru bail rejected.
My Lord, rejected.
Pechi.
My Lord.
2018 conviction put reaching.
My Lord, sentenced to arrive for 7 years and a fine of rupees 2,000 for offence commission under section 376 IPC and under section 3(2)(b) of SC/ST and life imprisonment was prescribed for that reason. Highest punishment is life for offence under section 3(2)(b) of SC and ST PO Act.
Notice तो जाइनी SC/ST Act रे bail अपनो
Notice
ना
today he is filing the bill.
हाँ नहीं सर जो जाने और जो अंदर क्या
आगुर है आगुर फाइल करना
आगुर से bail
देखो the London Council for the Appellant files the bail application in court, serving a copy of the Land Council for the state. Let the IA be registered. Since one of the offense under which the appellant has been found guilty is under section 3(2)(b) of the SC/ST PO Act, let a copy of the appeal memo also be served on the such answer by Monday morning, which will be sent to the inspector in charge of Umarkot police station for its service on the informant in Umarkot PS case number 74 of 2010, and it will be intimated to the informant that the matter will be taken up chutti for and she is at liberty to appear to advocate and opposing prayer for the usual order. It is registered on the
Item number 10.
Please, your lordship. I am there virtually, ma'am. Lords, here I have filed the surrender certificate in IA 2439 of 2024. To the annexure A/1 to that IA. And I have complied with all conditions that were imposed.
So, Panda, there are 3 criminal appeals.
Yes, my lord.
Which one you have?
It is 622.
622. 622
of 2015.
Oh, filing surrender certificate. All right. Surrender certificate filing.
Custody certificate. Custody certificate.
We have prayed for further bail.
No, surrender certificate.
Mixture A/1.
IA number
2439
2439 of 24 is the. Have you received a copy? Item number 2439 of 2024. Give him a copy.
My lords.
Copy has been filed, we have received. They have not probably added it. We'll serve a copy, let it come tomorrow then.
The Learning Council for the state submits that he has not received the copy of the interim application. It was the 622 of 2015 election. Hello, তাদের ওটা filing is দেখুন IN number 2439 of 2024. Hello, this bail application has been filed along with the surrender certificate. Hello, and counsel for the state submit that he has not received the copy of the interim application. The interim application be served on the Learning Council for the state. Since the petitioner has been released on interim bail by this court, as per order dated,
29/7 Miller.
29/7/2024 for a period of
1 month.
1 month. Let the Learning Council for the state obtain instructions from the concerned IAC about the
That we have also filed, Millers. Annexure A by 2.
Annexure A by 2.
A by 2.
Yes, my lords. That weekly appearances.
In mind, our order was there for release.
Oh, no, it is appear করছিল আপনি
Order dated 29/7/24 so that the interim application was withdrawn.
No. IN number 1571 of 2024 रे ତାକୁ ବେଲ୍ ଦିଆଯାଇଛି ଗୋଟେ ମାସ ପାଇଁ that is order serial number 11 order number 11 ଟାକୁ ଦେଖ IN number 115 10 number ଟାରେ ସେ not press କଲେ interim application ଟାକୁ 11 number order ରେ IN number 1571 of 24 ରେ ତାକୁ ମାସେ ବେଲ୍ ଦିଆଗଲା ଦେଖିଲେ ତ
Yes.
ତାର direction ଥିଲା he has to appear before the Sahid Nagar police station once in a week on so and so and he has annexed the documentary proof relating to his appearance before so and so.
Only in September we had allowed it.
You just take instruction
Why
about
is
this. So it will come after ensuing puja. Yes, next.
Maybe take a look.
Along with so and so other application. Yes, next.
Well, that may be taken up tomorrow. We'll serve the result.
Tomorrow is a holiday. Tomorrow.
Day after tomorrow.
No,
After
yes. Item 11, yes.
Item 11.
के ना की 500 thousand. Next.
Item 12.
Item 12 valid on possible. Can you pass?
Finish. Next.
Item 13.
Item 13 may I please, Lordship. Lordship, petitioner apply for interim bail, Lordship. Last date, your Lordship direct for instruction to the state government, Lordship.
Interim bail na कौन गुड़ा IASC extension of interim bail.
Lordship, petitioner granted interim bail, Lordship. Your coordinate bench passed the interim bail, Lordship.
Have you? No.
Lordship,
Whether you have surrendered or
Lordship, petitioner surrender. Then after
it has become infructuous.
Lordship, that I is interested. Again, Lordship, 1702 file, Lordship, for last your Lordship that last order kindly see, Lord.
Last order to 25/9/2024 रे.
Lordship, last date your Lordship dismiss that, dispose of that extension of time direct to file, Lordship, for instruction for state government, Lordship. Instruction by instruction by last date.
Extension you are not pressing because he has already surrendered according to you.
Lordship, I am filing for interim bail, Lordship.
Number से क्यों तू? आसीनी ब्रा. आइए number कितने?
1702 of 2000.
हाँ सेटा आसीनी record को आसीवो. 1702 of 2024.
Lordship.
है तो?
Lordship. So record
Petitioner is
Lordship Pradeep Giri. Lordship third case, Lordship.
Oh, third case टा.
Lordship.
वही ना तो हमें first case टा उधर ही.
Pradeep Giri third.
1702 আছে হার্ড কেসটা বার করো
Yes, lots.
যেটা হচ্ছে সিআরএল এ 180
185.
তাদের কোন অর্ডার হয়েছিল লাস্ট টাইম কোন বুঝিনি
That is health condition. Health condition of your mother.
আনিলে
Yes.
আইএন নম্বর 1702 of 24 আছে
That's the case.
ଦୁଇ ମାସ ନା ଅଢେଇ ମାସ ଦିଆ ହେଇଥିଲା 30th of June ପର୍ଯ୍ୟନ୍ତ ଏବେ ତ ଯାଇଛି ଜୁନରେ ଗ୍ରାଉଣ୍ଡ ମେଡିକାଲ
amputation in each leg. No accident. The petition seriously mother of the appellant to plan.
Mother of the appellant to put his cancer only.
His petitioner is saying, "Kौन इटा मुझे बोल? अब वो कौन है report दे उसे? कौन सा मारे इसे?
I come to report that I have inquired into the health condition of the mother of the appellant on the following points. Yes, the petitioner is seriously injured and amputation of.
ଆପଣ କହିଲେ ମାର ଆଣିବାକୁ କଣ
ସେଟା ମୋ କେସରେ
ସେଟା ସାର୍ fourth case ରେ ଆସିଥିଲା।
ଏଟା fourth case.
286.
Here on Pradeep Giri.
Pradeep Giri ହେଲା third case।
ଆସିନି
ଆସିଲା ଉପରେ ଯେଉଁ ଲେଖିଛନ୍ତି ପ୍ରଦୀପ ଗିରି ବୋଲି।
କୋଉଠି?
ୟା ଉପରେ
ସବଜେକ୍ଟ ରେଫରେନ୍ସ ଟୁ ପ୍ରଦୀପ ଗିରି ଲେଖା ହେଇଛି। CRL 385 of 16 filed by Pradeep Giri versus state.
Filed by Krishna Barik alias Rahul versus State of Orissa.
ରିପୋର୍ଟଟା ଦେଇଛନ୍ତି। ପୋଲିସ ରିପୋର୍ଟଟା ଯୋଉ ଦେଇଛି ସେଇଥିରେ ରେଫରେନ୍ସଟା ପଡିଛି।
ଏଇଟା ଆପଣ ଆମକୁ ବଢେଇଲେ କଣ ଲେଖା ହେଇଛି ଦେଖନ୍ତୁ।
It was 385.
Krishna Barik
Krishna Barik ମାନେ ତା ପରଟା ବର୍ତ୍ତମାନ ପ୍ରଦୀପ ବାରିକର ସେଇଟା ଦିଅ ଆରଟା ବି ସିଲ୍ ମରା ହେଇଗଲାଣି ଦିଅ।
Pradeep Giri is 385.
385.
Pradeep Giri. Father of the patient is seriously suffering from liver cancer. Document generated. No medical section. The father of the patient is staying in village. यादरे बेरले जाइतला से केबे
लॉर्डशिप
केबे
जाइतला लॉर्डशिप 12/4/2024
के दिन
लॉर्डशिप अप टू
30th of June ମାନେ 4 ରୁ 6 2 ମାସ ଅଢେଇ ମାସ
हाँ ठीक ठाक आपके अढ़ाई मास
ऑपरेशन टा ऑपरेट ही करनी चाहिए
ऑपरेशन हबो तू आगु जाइतला ठीक समय सरेंडर कर
लॉर्डशिप
ये कोठी ट्रीटमेंट होची यार
आचार्य हरिहर लॉर्डशिप एथरे लॉर्डशिप ऑनरेबल चीफ जस्टिस कोटे क्रिएट करथिला कमिटी भी रिपोर्ट देइछ लॉर्डशिप
कोनटा
जे ता मदर क हेइतला एसी मेडिकल ट्रीटमेंट चार्ज
माने मेडिकल डॉक्यूमेंट आईएसी तो कोनने रिपोर्ट थोड़ा जेन्युइन बोली
लॉर्डशिप
सिपुन बारिक केटा वाले आपण
सिपुन बारिक
ओइटा वाले ते गोटे केवल
Here only 286.
286 right. 385 he is the only male member.
Lordship.
385 only Pradeep Giri.
Pradeep Giri, Lordship.
24% inversion caste. 396 to 16 25 27 outside.
The document होगा तो ये अच्छा कि हमारे यहाँ वीडियो में आइए मतलब ଆଗରେ ଆପଣ ଦିଟା ପୁଣି ଏଥିରେ ବି ଦିଟା ଯୋଡି ଦେଇଛନ୍ତି ଏଇଟା ଗୋଟେ ହଉଛି ୟାର ତା ସାଙ୍ଗେ ସେ କୃଷ୍ଣା ବାରିକର ମିଶେଇ ଦେଇଛନ୍ତି ଏଟା କୃଷ୍ଣା ବାରିକଟା ଅଲଗା କରିଦିଅ ଆଜି କେବଳ ଫାଷ୍ଟ ପେଜଟା ଦିଅ କୃଷ୍ଣା ବାରିକ ସେ ମୁଭ ହେଲେ ଦବ ସେଟା ସେପାରେଟ କରିବ କଣଟା ଦେଲ এটা হচ্ছে সেকেন্ডটা হচ্ছে তার মানে এটা সেই একটা রকম কেবল এই উপরটা ভাগ করতে বাকি সে ডকুমেন্ট ସବୁ ডবল আসছে দিস ইজ কেবল উপর কাগজটা ମୁଁ ତ ବୁଝିପାରୁନି ଏ ଯୋଉ କାଗଜଟା ଫ୍ରଣ୍ଟ ପେପରଟା ଦିଅ ପ୍ରଦୀପ Hard dealer and counsel for the petition and counsel for the state. This is IL number 1702 of 24, an application for interim bail on the ground of ground that the mother of the petitioner is suffering from liver cancer. And for the treatment of the his mother, the presence of the petitioner is necessary. The learned counsel for the state was asked to obtain instructions on the application, and today he has produced the report of the IIC Telpui police station, which indicates that this petitioner's mother is suffering from liver cancer, and the documents attached to the IAS by the petitioner is genuine, and only father of the petitioner is old is there in the house. The report is taken on record, considering the amendments taken in the interim application hearing the land council for both the parties and the report obtained by the land council for the state. We are inclined to release the petition on interim bail for a period of 1 month. I will disclose no PS to file the surrender certificate. They will also necessarily the stay of realization of time. Stay of time. Yes.
CR 286
Nobody कौन आला को interim bail कौन पाई
or younger brother left leg from knee amputed.
देखिए सेटा दियो दिखाई दो तो ना देखो कृष्णा बारिक ना की बोलते हैं कृष्णा बारिक हाँ डॉक्यूमेंट उड़ा दिया इसमें हाँ सही देखा
মানে এবার রিসেন্ট ডকুমেন্ট দেখতে এটা অ্যানেক্সার 1টা অ্যানেক্সার 1টা কে পেল এটা জানুয়ারি
सानो भाई ये सानो भाई ना कैसे
Yes.
জানুয়ারির তারিখ এটা this amputation was sometime in January. So you were in
Sipun Mari got upon paragraph 2 election the IRA that the younger brother of the petitioner named is Sipun Bari got injured owing to road accident for which the left leg so and so knee joint dislocation hela so and so एम्स रे रहिला तापरे amputation हला discharge हला 12/1/2024 रे no male member to take care of this one so eta hochi तापरे also document genuine ଅଛି
He's in custody since more than 10 years.
ଆପଣ interim bail ଟା file କରିଦିଅନ୍ତୁ ଦିଟା କଣ interim bail ଦେଇଛି
ଆଗରୁ ଗୋଟେ 20 ମସିହାରେ ଫାଇଲ ହେଇଥିଲା for mother illness is not present.
IN number 1256 of 2020 there is an application for interim bail does not want to press this application है ना बाकी जो IN number 48 of 24
ମେରିଟରେ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି 19ରେ ନାଇଁ
IN number 448 of 24 there is an application for interim bail on the ground that the younger brother of the petitioner was got injured in the road accident and his left leg was amputated and there is no other male member in the family to look after him. The Land Council for the state was asked to obtain instruction on this interim application today. The Land Council for the state has produced the report of the IIC Telpui police station, which indicates that the brother of the petitioner was seriously injured and there was amputation of left leg and the documents attached to the IA by the petitioner are genuine and there is no male member to look after the injured. Considering the submission made by the Land Council for the respective parties, looking at the amendments made, document annexed, and report obtained by the Land Council for the state, we are inclined to release the petitioner on interim bail for a period of 1 month. Eta starting karo. Yes, next.
Lordship, I have one question. Can you take the soft copy of this, Lordship? In this case, Lordship, from this computer, Lordship. You want soft copy of that?
You pass on your pen drive, you will be provided to you. The the London Council for the it has CRLA 385.
Lordship,
London Council submit that is maybe supplied with the copy of the appeal member, who also the evidence copy and the copy of the judgment pen drive. That the registry supply the same in the pen drive. Next.
Item number 13.
In this case,
surrender certificate.
Your Lordship's written instruction from
Date of appellant number 8.
Yes, we have sought for the instruction but not received yet. That person from different Jharkhand Simdega.
Like the London Council for the state submits that some more time may be granted for obtaining instruction regarding the death of appellant number 8 Sujana Nayak, put of this matter after winter age of next.
Item 15. Lordship, in this case, I am appearing for the appellant and prisoner person at their Lordship.
Prisoner person, flat C.
File court in Vinama file.
Lordship.
Mandakini Panda.
Look on the prisoner's petition at flat C, in which a request has been made for engagement of Mandakini Panda as the appropriate. The London Council has filed the Vinama. The Vinama is accepted. They accept the name of Mandakini Panda. The other name shall not be reflected in the cause this stands for. Yes, outcome 5.
Still, the prisoner has been convicted under section 302 IPC, Lordship, and he is in custody more than 8 years, Lordship.
अच्छा आपनोडा डेट चार्ट अछि आ देबे
Lordship से previous council.
हां ठीक अछि प्रीवियस काउंसिल फाइल करछन तो देखिबार कोन मना अछि
Lordship.
अच्छा 19
was rejected.
हां 19/2006 रे अरेस्ट अच्छा बेल मेरिट रिजेक्ट ही
Yes, 3/12/2018.
हां 3/12/2018 तो एलिगेशन कोन आपने बताबे
Lordship. Lordship, on 15/5/2011, Bahura Parva was celebrated in village Badajura, and a dance program was going on in the village. While the deceased was dancing, the present appellant came there, being armed with a knife, and dealt a knife blow on the left side back of the deceased. And the appellant removed.
चौथी पर्व होतला
Lordship.
PW1 evidence अछि चौथी पर्व होतला
Shukramud.
पैराग्राफ नंबर 5 रे अछि नाइफ रे इंजुरी कले सिंगल गो बोले
Died on the spot.
Died on this spot. Knife was seized. PM report is consistent with this one. And counsel for the petitioner and counsel for the state. The London Council for the petitioner submit that the petitioner was taken into judicial custody on 19/1/2016, and his earlier bail application was rejected by this court by order dated 3/12/2018, and Since there is no chance of early hearing, we appeal in the near future. The bail application will be favorably considered. Plan counsel for the state of the for bail. Consider the submission, nature of evidence available on the court. While not intending to believe the petitioner on bail on merit, but taking into account the period of detention in judicial custody, absence of any chance of unveiling, and the ratio laid down in the case of Letty versus Lawrence. 3 months again granted, and he has to file the surrender certificate. He has to file the surrender certificate. The date account bail file to the
My application lordship 1257.
1257. Item not post for them. Losses of pistol not post for them. Yes. Next.
Item 16. May I please, Your Lordship? My lord, here in this case, there is 2 appeals and 3% face trial. And in the first appeal, there is 2%. Out of them, against 1%, the conviction is set aside. The appellant number 1. As he is found as a juvenile, so his proceeding against him is terminated. And the next person, that is Ramaji alias Santosh Prasad. He is inside custody since 3/2012, my lord. And my lord, there is nothing material against his present appellant, but out of the FIR, it is only stated that he is standing there and only stated that Mara Mara. And in this case, there is only one eyewitness to the occurrence. Out of love triangle, his death.
Who is that eyewitness?
My lord, PW2.
This is the Vijay.
My lord. Vijay Kumar Singh. Cause of death due to gunshot injury.
I proceeded toward my house intending to inform Vijay about the matter. By the time Vijay came from my front side, my motorcycle, at this, the accused persons came from my behind and gave pushes to the motorcycle of Vijay. Accused Dinesh fired my action.
Next appeal, madam. In 4 CRL 4 is.
ये अपन जोटा बर्तन मूव करजन ताना कौन?
Ramaji. Ramji alias Santosh Prasad.
Santosh Prasad. So you mean to say that as per the evidence of that eyewitness,
Madam, only evidence that
PW2,
PW2.
your role is that you push that motorcycle, then he fell down, the deceased fell down, and then who fired gunshot? Dinesh. Your bail application was not rejected on merit earlier?
No, my lord. Bail application is pending. 1400 of 2019 IA number. My lord, custody is 3/12/2012.
ଆପଣଙ୍କର 2012 ମାନେ 12 ବର୍ଷ ହେଇନି 11 ବର୍ଷ କେତେ
9 months.
Run counsel for the state. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody since 3/12/2012. PW2 is an eyewitness to the occurrence who has stated specifically that it is what is Dinesh Mahato who fired gunshot at the deceased which resulted in his death. And the role attributed against the petitioner is that he pushed the motorcycle of the deceased, for which he fell down on the ground. The Learned Counsel submits that in view of the period of detention of the petitioner in judicial custody and absence of any chance of early hearing of the appeal in the near future since paper book has not been prepared, the bail application of the petitioner will be favorably considered. Learned Counsel for the state approves the prayer for bail. Considering the submission, nature of evidence adduced, in view of the eyewitness accounts, also the postmortem report signing, while not intending to release the petitioner on bail on merit, but taking into account the period of detention and judicial custody. I'm inclined to release the petitioner and let it get supported of 3 months bail granted. Enough. This Dinesh is the main accused.
Dinesh earlier released on bail for his father's death and surrendered voluntarily in 19 to 2021, my lord. And at the time of occurrence, he is as his date of birth is 1994, he is nearly about 18 years or some.
No, it was terminated. No, he had already undergone 10 years.
My lord.
And the maximum period for juvenility was 3 years. That is how the entire period is terminated.
My lord.
That is. So he is not alien.
Next.
Item 17. My lord. There is two. My lord, second appeal for Dinesh Mahato, who is the my lord 487.
Dinesh Mahato. You're a main
My lord.
It's CK.
My lord, he is also on the same day, 3/12/2012.
Right after puja vacation. Yes. Next.
Much obliged. Item 17.
The petitioner is in custody since 29/4/2015.
17.
29/4/2015.
2015. Near about 10 years. 9 months, 9 years, 5 months.
9 years, 5 years. Agu rejected is married.
No, my lord.
Allegation against you.
Allegation that while the deceased was gossiping with PW1, the present appellant went there and assaulted by means of an axe.
Iron rod.
Axe.
Axe.
Yes, my lord.
Eyewitness achandi.
Yes. PW1 is the eyewitness, my lord.
1 and 3.
1 and 3.
PW1 and 3 eyewitness.
Yes, my lord.
12 times.
How ye doctor ki
18.
18.
Yes, my lord.
One cartoon. 8 cartoon.
PW1 and 2 stated that there are no injury, but
only in the face area.
Doctor reports that there are 8 injuries.
8 injuries.
Yes, my lord.
8 ଆପଣ ତ ଏକୁଟିଆ ଧରିଥିଲେ ଆଉ କିଏ ମାରିବ?
But 2 axes has been seized, my lord.
No, eyewitness account is that you only assaulted.
Yes, my lord.
Yes.
Anybody else was present with you?
At the time, the son of the deceased also present, PW20.
Evidence କଣ ଆପଣ ଏକୁଟିଆ ମାରିଲେ ତ ଆକ୍ସରେ?
Yes, my lord.
That date is correct. The final form on 30/4 अच्छा 30/4
Yes, कितने वर्ष तक 15/8/23 8 वर्ष
8 वर्ष नहीं 9 से EDC child behavior control. Now also are the learning council for the petition and council for the state. The learning council for the petitioner submits that the petition is into research custody since 2015, and therefore he has remained in custody for more than 9 years, and no chance of early hearing. Balance of convenience is in his favor, therefore the their application may be favorably considered. Learning council for the state opposes the for bail. Place the evidence of PW1 and 3 were the eyewitnesses to the occurrence, and the evidence of the doctor, bracketed PW 18, who has noticed number of injuries on different parts, vital part of the body, and opined that the cause of death was due to head injuries and intracranial hemorrhage. Considering the available material on record, while not inclining to release the petitioner on merit, but taking into account its period of detention and physical custody, absence of any chance, early hearing, and the principle laid down in the case of Letty versus 3 months bail grant. Yes.
Okay.
Number 18.
Yes, sir. He was released on bail, no surrender certificate, and non appears. The petitioner seems to have been directed to be released on bail for a period of 3 months by this court. By order dated 2024 in IN number 65 of 2020. Let an instruction be obtained from the learned trial as to whether the petitioner availed the interim bail period or not, and if so, whether he has surrendered in the meantime after availing the interim bail period. Let the file be placed before and registered judicial. We shall make necessary communication with the so and so in that respect. Yes, matter be placed after ensuing puja with the report of the current trial.
Item 19.
May I please, my lord.
Yeah.
In this case, last occasion, Honorable Court called for a custody certificate. The custody certificate file. It is proof that petitioner is a custody 14 ବର୍ଷ 4 ଦିନ ନା 5 ଦିନ flag is.
କେତେ
14 years something man.
କୋଉଠି କହିଲେ ନାଁଟା କଣ ଆର
ସୁଖଦେବ ବେହେରା।
ସୁଖଦେବ ବେହେରା 10 ବର୍ଷ ତଳେ ଖାଇ
10 years.
ନାଇଁ 14 years ମାନେ।
ଏଇଟା କେବେ କାଢିଲି
ଏବେ just ଆସିଛି after passing by honorable court my lord. ଏଠି ଲେଖା ହେଇଛି।
ଏଇଟା ଯୋଉ ଆପଣ B ରେ ଯୋଉଟା ଅଛି ସେଟା ଦେଖୁଛି 10 ବର୍ଷ 2 ମାସ।
ଏଇଟା ଦେଖୁଛି total sentence including remains 14 years 2 ଦିନ।
ଏଇଟା ପୁରୁଣା କାମ ନେଇଥିବ। Mr. Deepati, चाड़ी चल गया था।
मैडम जी
वो फटी हुई थी।
One of his father.
Madam, in this case, 302 absolutely not made out. Minus function to my lord.
The United Council for the petition submitted the petition is in initial custody for 14 years, and the appeal is of the year 2019. There is no chance of appeal. Therefore, the their application may be favorably considered. and counsel for the state oppose the prayer for bail. Eyewitness achandi.
Yes,
Madam.
eyewitness PW1 and 3.
PW3 na? PW1 and PW3. Madam, PW3 is white man. PW1 and 3 are the eyewitnesses.
Yes.
PW1 and 3 are the eyewitnesses who supported the prosecution case.
No,
and doctor is
hostile.
PW3 hostile man. Not supported.
Wife hostile.
Madam?
Wife hostile.
Hostile man. PW1 has supported.
Not supported my lord. ସେ କହୁଛି ଯେ ମାଂସ ବିକିବାକୁ ବାପ ପୁଅ ଯାଇଥିଲେ ଆସିଲେ ସ୍ତ୍ରୀ କି କହିଲା ମୁଜଲା ଯେ ରୋଷେଇ କର ସେ ରୋଷେଇ କଲାନି ଗଣ୍ଡଗୋଳ ହେଲା ବାପ ଯାଇକି
ଇଣ୍ଟରଫେयर କଲା ବେଳକୁ ତାକୁ ମାରିଲା ଆଉ କଣ
ବାପ ଯାଇ ଚାପଡ଼ା ମାରିଲା ପୁଅକୁ କାହିଁ ମୋ ବୋହୂକୁ ମାରୁଛୁ ସେ ଗୋଟେ ଗାଡିରେ ଥିଲା ବାଡି ଦେଇ ପଳେଇଲା ଯାଇକି ଫୋନ କରି କହିଲା ଯେ ବାପା ପଡିଛି ମେଡିକାଲ ନିଅ କେହି ମେଡିକାଲକୁ ନେଲେନି ଡକ୍ଟର ଇଞ୍ଜୁରି ଦେଖୁଛି
PW11 noticed lacerated wounds on the vital part of the body. Considering the submission made by the counsel for the respective party, while not inclining to believe the petitioner on bail or merit, but taking into account the previous attention in judicial custody and keeping in view the ratio laid down in the case of guilty swan, so 3 months bail now. Yes, next. Yes, next.
ହିୟରିଂ କରିଦବା ଫାଇନାଲଟା
20.
ଫାଇନାଲ ହିୟରିଂ କରିବା କହୁଛ ନା କଣ କହୁଛନ୍ତି
Item number 20.
ଆପଣ କହୁଛନ୍ତି ମେରିଟ ନାହିଁ ଫାଇନାଲ କରିଦବା ନା କଣ କହୁଛନ୍ତି ଛାଡିଦବା ଏବେ ବେଲ କରିବାନି
ମେଡିକାଲ ନେଲେନି ବୋଲି
Yes, next. Item 20.
Please, my lord. Last my lord, custody certificate was called for.
କେତେ ଆସିଲା?
ପିଟିସନ ଟିକେ ହେଇଥିଲା
10 years କହୁଛନ୍ତି ସେଟା ସବମିଶନ ଥିଲା
8 ବର୍ଷ 8 ବର୍ଷ
ଦାସିଆ ଆଲିଆସ ଦାସ
କଣ କଲେ ଆପଣ? Allegation କଣ?
Allegation my lord, petitioner fired at the deceased man.
125-27.
PW10 my lord, the doctor of the deceased my lord, and PW3 the son of the deceased man. And no
3 and 10 are eyewitness to the occurrence.
3 not eyewitness, but 10 is the eyewitness man. ଶୁଣିଲା
କାହାକୁ ଫାୟାର କଲେ?
mother, the wife of the informant, my lord.
ନିବାସୀ ମୁଦୁଲି.
My lord. Prior to occurrence, petitioner came to the house thrice, my lord, but search for the husband of the deceased, my lord, could not trace her, so that and prior to occurrence, my lord, they have
ବନ୍ଧୁକ କୋଉଟା ହେଲା? ଆଉ କେତେ କେସ୍ ଅଛି ଆପଣଙ୍କ ନାଁରେ?
It is seized from the co-accused, my lord. The pistol has been seized from the co-accused, my lord.
ଆଉ କଣ ଅଛି? କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ?
ନାଇଁ, no antecedent.
ବନ୍ଧୁ ଅଛି ନା ପୂଜା ପର୍ବଣ ଅଛି
ବନ୍ଧୁଟା co-accused ପାଖରୁ ସିଟ୍ ହେଇଥିଲା ତାରି ଘରୁ ଆଣିକିରି ଇଏ ମାରିଥିଲା ବୋଲି allegation.
The Laren Council for the state has produced the custody certificate of the petitioner, which is stated on that form. Since the allegation against the petitioner is that he fired gunshot at the deceased, as per the version of the eyewitness taken PW10, that the Laren Council for the state obtained instruction about the criminal antecedent against the petitioner. Yes, next.
Okay. Action number 21. May I please? My lord, status report was called from last one.
On status report?
Custody certificate.
Custody certificate?
Sorry, custody certificate.
ଆଣିଲେ କି?
ମୋବାଇଲ 8 ଜୁନ ହେଇଥିଲା
ହଁ
15/7
ସତର ନା
ହଁ
ଲାଷ୍ଟ
କେବେ
21 ତ
ଆଇଟମ 21 ତ
ଆଜ୍ଞା
CRL 569 of 2020
JCR 100
JCRL
ମୁଁ ଏଇଟା ତ ନାହିଁ
next
item number 22.
କିଛି ବେଲ ଫେଲ ନାହିଁ ମାଗି ନାହାନ୍ତି କିଛି ସେଠି ବେଲ ପାଇଁ ନାହିଁ
ତାପରେ next
Item 23. Offering for password for the day.
next
Applies. Item 24.
My lord, kindly allow the matter to be taken up after the puja vacation.
yes
Please.
Item 25. Item 45. Appellant file interim bail for treatment of medical. Medical treatment. Appellant Jodha Elias Sasadabal Naik.
କେତେ ନମ୍ବର ଆପଣ ଗୁଡାଏ ଅଛି 25
CRA
ମୁଁ କରୁଛନ୍ତି
215/22.
215
ଯୋଦ୍ଧା ଏଲିଆସ ଶେଷଦେବ ନାୟକ
That's it. IM number 2417.
ଆଚ୍ଛା ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ୍ କରିଥିଲେ
That's it.
କଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିଲା କି ଦେଖିଲେ 215
ଏସବୁ
फर्स्ट डे है ना से नोटिंग कर दो से है ना ये in the first hour after fresh admission this matter kind of second hour cut off benches है ना ये जो लेफ्ट ओवर मैटर्स तो तुम्हें लिख दो लेफ्ट ओवर ऑर्डर्स मैटर है ना of the weekly stated so and so will be taken off after fresh admission है ना and launch करे cut off benches that's all